Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Good morning. Today's Thursday, May 14th, 2026. And thank you so much for coming to spend part of your day with me. How's everybody doing today? How about those Avs, huh? Was that a great game? Coming back in overtime for the win. Moving on to the next bracket. It was amazing. That was an amazing game. Did you watch it? Let's go Avs. Yeah, I think the Avs play the Canes, right? And the next, are they playing the Canes next? Tell me, because I haven't looked at the bracket and I've been, busy with you guys all day. Boy, did that sentencing take so much longer yesterday than I thought it would. Corey Richins. Still so mad about Courthouse Becky. Well, Miss Becky, who's happier than Alex Murdaugh today? I don't know. Yeah, so the Avs came back in the third period. It was going into the third period? 3-1 or 3-0. They came back, scored 2 goals quickly in the third, and then it went into overtime, and then they scored a goal, and then they won. Yay! That was a great game. Yeah, I can't wait. I love hockey playoff season is my favorite season of the year. You know that. It was wild. We thought Sarah Boone was bad. Remember when Sarah Boone spoke at her sentencing? Yesterday, if you didn't watch the Corey Richins performance, her monologue, that I don't know what was the final count on minutes. She said she was going to be a half an hour. I think it was longer than that. It was wild. It was crazy. Go back and watch it. I timestamped it for you, so you can go right to the part where she starts to talk, and then you can go right to the verdict if you want, or actually the sentencing. I haven't had enough coffee yet today. How are you guys doing? Oh, the Golden Knights also won in overtime. Your coach, John Tortorella, used to coach the Rangers years ago, and so I have a special fondness for Tortorella. He was a crazy guy at the time. He was a loudmouth. Seems that he's toned it down a little bit, though. Has he, Michelle? Jenna said it was like Donna Adelson, Sarah Boone mixed together. But almost even worse. Like she's so tone deaf. Directing her entire speech to her boys who made it public that they want nothing to do with her, don't even call her mom anymore, and just are so afraid of her, and revealed some more horrific things that she allegedly did to them and their pets and their farm animals. It was insane. Oh, thanks. Thanks, Lara Wilson, because I was going to ask you this, what your thoughts are and whether he's guilty or not. Lara says, I know I'm at minority here, but I don't believe Alex is guilty. I watched the hearing and the judges had multiple problems with the trial too. I don't like Alex. I think he's awful. Alec. Well, it's spelled Alex. He calls himself Alec. It's also Murdaugh. A lot of people say Murdaugh, but it's Murdaugh. Remember we talked about the Hulu series with Patricia Arquette and Jason Clarke. And I really thought the Hulu series was done well. And I liked it a lot. But I just want to know, so you don't think Alec did it? It's going back for a new trial. I watched the Attorney General this morning and Creighton Waters. I can pull that up for you. I think it was yesterday, actually. They intend to try him and they want to try him again before the end of the year. That's what they're going to try and do. So listen, that trial was in 2023, January through March. It was a 6-week trial. That was way before I was on YouTube. I didn't start my channel until July of 2023, so I'm here for it. I'm here for every single minute of it. For me, it was the Snapchat video. Snapchat, I always tell you that social media is bad, not YouTube, but I think the Snapchat video, in my opinion, is what sunk him. And it caught him at a lie. And I also felt that his testimony with the sniveling and all the mucus running down his face, I just didn't have any sympathy for him at all. But the second trial is going to be a whole new trial, a whole new trial. And he may not testify at the second trial. There may be a lot of evidence about the financial crimes that won't come in. And there is a local rule in South Carolina that I heard Harpootlian talking about, that if Alec does not testify at the second trial, they cannot use his first trial testimony at all. And so there's interesting. No, he's not going to be allowed out on bail because he's already doing time for his financial crimes that he pled guilty to. So he's not going to see the light of day anytime soon, if ever. He's serving something like 27 years. He pled guilty. He got 27 years for the financial crimes and another 40 years on federal crimes. So he's not going anywhere anytime soon. So don't worry about that. He will not be roaming about the cabin freely. It has been my opinion since I first covered this on my own channel, which was in September of 2023. I said, he's getting a new trial, you guys. Wait for it. It's going to happen. Every defendant's entitled to a fair trial. There were a lot of issues. And my biggest issue at the time, and still is today, court clerk Becky Hill's interference with the jury. Jury interference is a big thing. I've got her book. And I remember when she came out to talk about her book, and then it came out that she plagiarized her book. And then her co-writer did some interviews with the guy, Neil Gordon, and said he didn't want anything to do with her. And because she plagiarized portions of the book, and they were pulling the book from Amazon, and it was already off Amazon. And I said, let me see. So I went on Amazon. I grabbed myself a copy. I sent my mod Scott a copy too. 25 years on the job, a copy. We both have a copy. And now Scott sent me yesterday, this book right here is going for $500 on Amazon, the paperback version. I think it's $2,500 for the hardcover copy, which they didn't have at the time I bought it. So I bought the paperback. It's now going for $500. So that is interesting. Does anybody else have the book? I haven't read it, but we'll see. Let's talk about, let's see. What should we do first? We're going to read the decision. It's 29 pages long, so buckle in for that. And we're going to talk about the new trial that we're going to start covering on Monday, which is very interesting. Oh, you bought one as well? Did you get it? It was like $10, or it was cheap. It was, I don't even know how much. Samantha got one too. And she's on probation, so she didn't get any jail time. I think she should have been treated a little more harshly, because jury tampering is a real thing, and it's a crime. And now look at how much money the state of South Carolina is going to have to spend to retry this guy, but they're doing it. We'll play that little, not really a press conference, but they did some comments to the press yesterday. Creighton Waters and the Attorney General. The Attorney General is running for governor, and he says he wants to try them. He wants to try them again before the end of the year. Harpootlian doesn't think it's going to happen that fast, but the first thing that has to happen, it has to go back down to the lower court, and they have to assign a judge, and they have to start talking about it. Harpootlian thinks he's going to automatically get a change of venue, and so it'll probably go to a different county, and we'll see what happens. But I'm here for it. Would you watch it again? Some people are like, I'm tapped out. I can't watch Alex Murdaugh again. All right, let's talk about today's motivational quote of the day. Kelly says she thinks that she should have to pay for a new trial. I think she got a slap on the wrist. I think she should have been punished much more harshly than she was. Will Durant said, education is a progressive discovery of our own ignorance. That's interesting. Education is a progressive discovery of our own ignorance. There's your motivational quote of the day. Dun, dun, dun. And your empowerment card of the day, because who doesn't need a little empowerment? I think the new trial is going to look very different as well. Dagny. I do too. I'm totally in it. If it happens before the end of the year, I mean, that'd be great. Get it over with. Here we go. Here's your empowerment card of the day. Dun, dun, dun. All right, here we go. It's a good one. Maybe some of you needed to hear this today. Believe in yourself and you will be unstoppable. Believe in yourself and you will be unstoppable. Unstoppable. You heard it here first. All right, a couple new props. Oh, well, one new prop. Found this when I was cleaning out my daughter's old room to redecorate it, because now she has moved into another part of the house. Here, hang on. Check this out. It's a little tiny violin. You might have seen. I broke this out yesterday during Corey Richard's little speech. Here's the little tiniest violin in the world for those people who need just a little sympathy. $1,200 on eBay. Hi, Brittany. How are you doing? $1,200 for the paperback copy. I guess I should put this like in a dust jacket somewhere. And a good thing I never cracked it open. Doors of Justice. Behind the Doors of Justice, the Murdaugh Murders by Court Clerk Becky Hill. I've linked in the show notes below this video my first stream from September of 2023, in which I said I think 100% he's getting a new trial. We went over at that time the motion for the new trial. It was a little cringe for me to watch because it was right when I started my channel, and I was like, ooh, it's so awkward. But go back and watch it just so I can say, I was right. I told you so. And I also put in there the link to another Murdaugh show that we did. And then remember, even more recently, when we were talking about the Hulu docu-series, or the Hulu miniseries. It's not a documentary at all. It's a scripted miniseries. Moselle, the estate that Murdaugh may or may not have killed Maggie and Pawpaw at, was on the market, and we looked at the listing for that, because you know me, I love looking at the listings. All right, let's take a look. Let's get to the decision, because it's a long one. And Aidan Carney's hearing has been postponed without date. I don't think there's a new date yet, so that's not happening today. One of his attorneys had a family emergency, so it's been moved. Karen Reed has a civil hearing at 3. I won't be able to live stream it, but if somebody posts a copy of it afterwards, we can talk about it at some time in the future or later today. On top, thanks for your super sticker. Gina needs to know, thank you very much for your super sticker. And Salty Mom says, my son is in Season of Drought premiere May 30th. I don't know what that is. Is it a TV show? Salty Mom, is it a movie? I don't know what that is, but congratulations. Very happy for you. Thanks for hanging out with me for 10 months. Yeah, the housekeeper, who said that? The housekeeper had some great interviews post-verdict. And her book is great. She thinks that he didn't act alone. I agree. You're not talking about Gloria, right? Gloria Satterfield died. So I'm not sure what the housekeeper's name was. But thank you, Mustangs, Hallie. And let us move on to the decision and see if you agree with it. All right, here we go. Aiden said it's going to be sometime in July. Karen's was canceled. The parties agreed to the discovery. Okay, so that's not happening either. I looked at the court calendar this morning in Plymouth. It was on for 3 p.m., but if the town of Canton has agreed that they're going to give up the records of Canton police suspended Canton police officer Sean up to no good, then I guess they don't need the conference. So that's good. I don't know if I can watch the whole trial one. It's 6 weeks long. It is 6 weeks long. We can watch. Maybe we could watch portions of it. We could watch his testimony and things like that. If there's certain parts of it that you want to watch, that would be fun to do. Well, the housekeeper's name was Gloria. She didn't write the book, though, Brittany. She's the one who fell down the stairs, and then she died, and then he stole the money that should have gone to his sons. But there was a different housekeeper. I know she's talking about who wrote a book. And it was not Gloria. It was somebody else. All right, here we go. Yeah, this is the state of South Carolina Supreme Court decision. It was a unanimous opinion, too, and there was no dissent, which is interesting. It was argued on February 11th of 2026, and the decision was filed yesterday, May 13th, 2026, so right around the 90-day mark. Well, please. And I'm going to need to hydrate a lot. Whenever I say hold, please, it's because I need to take a sip. And before I started my YouTube channel, I did not know that misophonia was a thing, and certain people get very triggered and upset if I make any swallowing noises into the mic. So I'm accommodating. I'm accommodating, and I mute when I sip, but I'm going to have to sip a lot because this is going to be a long read, and my voice is already tired from yesterday. All right, here we go. Per curiam, that means by the court, which means that it wasn't signed individually. It's like they all are agreeing that this is their decision. For 6 weeks in early 2023, the eyes of the nation focused on Colleton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife Maggie and son Paul, or Paw, as he called him. Both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. However, their efforts were in vain because Colleton County Clerk of Court, Rebecca Hill, placed her fingers on the scales of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. There it is. Right in the second sentence. Yes. Can you tell me, thank you for reminding me, why does everybody, or at least Alex Murdaugh, call everybody Bo? Why does he call everybody Bo? Hey, Bo. Hey, it's Doom, Bo. What is that? Is that low country slang? Does it mean like, hey, buddy? Blanca. Her name was Blanca, right? Housekeeper. Okay, moving on. Slang for bud. That's what I thought. Like dude, like hey, dude. What's up, Bo? Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury toward a biased verdict. Although we are aware of the time, money, and effort expended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for a new trial due to Hill's improper external influences on the jury and remand for a new trial. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raises on appeal from his conviction. On this thorny issue on the trial to the trial court on remand. So it is going right back for a new trial. It's not going back for a new hearing on whether there should be a new trial. It's going right back for a new trial. And the only reason they're reversing it is because of what Becky Hill did. They don't even need to get to the other issues, but in giving some guidance to the next trial judge, they are telling him or her, what their opinion is about whether or not those financial crimes should be admissible. On March 2nd, 2023, Murdaugh was convicted of the murders of his wife, Margaret Murdaugh, and his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime. The trial court, Judge Newman, sentenced him to life in prison. While his direct appeal of these convictions was pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance to allow him to file a motion for a new trial. The Court of Appeals granted that motion. On October 27th of 2023, Murdaugh moved for a new trial, asserting Hill tampered with the jury by 1, advising it to not believe Murdaugh's testimony and other defense evidence, 2, pressuring it to reach a quick guilty verdict, and 3, misrepresenting information to the trial court in an attempt to have the court remove a juror that she believed to favor the defense. He attached affidavits from several jurors to support his motion. Chief Justice Beatty appointed former Justice Toll, post-trial court, to preside over this motion as the trial court judge had recused himself. That was Newman. Remember the shenanigans with the egg lady juror and the alleged Facebook posts made by her alleged ex-husband. It was crazy, and Becky Hill had no receipts for it. The post-trial court conducted the hearing of this motion on January 26th and 29th of 2024. During the hearing, the post-trial court asked each juror, 1, if the guilty verdict was an accurate statement about their verdict at that time, 2, whether their verdict was based entirely on testimony, evidence, and law presented in the case, 3, whether they heard Hill make any comment about the case before the verdict, and 4, whether their verdict was influenced in any way by any communications by Hill. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill saying before Murdaugh's testimony, quote, "Looks like the defendant is going to testify. This is an important day," or "This is an epic day," and that it was rare for a defendant to testify. Juror X said these statements did not impact the verdict. Juror Z, who submitted one of the affidavits Murdaugh attached to his motion for a new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said to, quote, "watch his actions and to watch him closely." Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influenced her finding Murdaugh guilty because, to me, it felt like she made it seem like he was already guilty. That's it. Stop. Full stop. End of story. I said this all the way back in 2023. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror Z's affidavit gave a more detailed recitation of Hill's comments. And this is quoting. Toward the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury to, quote, "not be fooled by the evidence presented by Mr. Murdaugh's attorneys," which I understood to mean that Mr. Murdaugh would lie when he testifies. She also instructed the jury to watch him closely immediately before he testified, including to look at his actions and look at his movements, which I understood to mean he was guilty. Juror Z testified that when the jury began deliberations, Hill told the jury, "This shouldn't take us long." In addition to referencing Hill's statements, Juror Z averred in her affidavit, "I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors." Hang on one sec. It's weird because the opinion starts on page 8. Okay, but I'm like, are we already on page 10? That can't be, but we are. But it's really page 3. After reviewing the affidavit, the post-trial court questioned Juror Z. "I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes, in light of what you said in the affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt? Jersey answered affirmatively. The post-trial court then asked if she stood by the affidavit, and she answered yes. Jersey subsequently submitted an affidavit to clarify her testimony, in which she explained that she felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room. And once deliberations began, she felt additional pressure from the other jurors to reach a guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court. Part of the state's argument was that the Supreme Court should not even consider that affidavit because the trial court, Judge Toll, did not consider it. And they considered it anyway, as they should have, in my opinion. Juror P testified that on the day that Murdaugh was to take the stand, Hill made a comment to, quote, watch his body language. He denied Hill's comments influenced him in any way. Footnote 1. The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced by any comments that Hill made. Footnote 1 says, following Juror Z's testimony, the post-trial court informed the parties that the other jurors who were waiting for their turn to testify had tuned into the proceeding on court TV. The jurors either denied viewing the proceeding or, if they saw it, asserted it would not influence their testimony. Wow. This happens in so many cases where witnesses who are not supposed to be watching the trial are actually watching the trial on their phones on court TV or elsewhere on YouTube. Following the jurors' testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related, she admitted that on the day Murdaugh testified and within earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. She also stated that she gave the jurors, quote, a little talk, instructing them to pay attention and that the day was a big day, a big day. She denied attempting to influence the jury. Sadly for her, it is not her intent that matters here. But moving on to the opinion. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, here it is right here. Footnote 2, Hill claimed literary license to explain some of the more dramatic passages. Let's see what footnote 2 says. As her book's title suggests, it turns out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publication because Hill plagiarized portions of it. Not before Scott and I got a copy. That's hilarious. They have a little sense of humor. As her book title suggests, it turns out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. I love a little snark from a Supreme Court. Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her. But she acknowledged as true a passage in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of his family's goodwill in the community. The post-trial court also questioned Hill about the favors she granted the media. Hill denied allowing the press to view the exhibits, including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial. Although the post-trial court limited discussion of juror 785, footnote 3, whom the trial court dismissed on the day deliberations began for allegedly discussing the case with third parties, it allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from juror 785's ex-husband. That was the egg lady juror. Footnote 3 reads, When the trial court dismissed Juror 785, she said her belongings left in the jury room included a dozen eggs, which another juror had brought her. She then became known as the egg juror or egg lady. Hill claimed that the juror was very talkative while Hill walked her to the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. In response to the post-trial court's questioning, Hill continued to deny initiating or engaging the juror in discussion of these matters. In contrast to Hill's testimony, Juror 785 averred at the hearing before the trial court and in an affidavit Murdaugh attached to his motion for a new trial, footnote 4, that Hill interrogated her about the social media posts and whether she had been in contact with her ex-husband. Footnote 4 reads, although the post-trial court did not allow Juror 785 to testify, her affidavit is in the record for our consideration. Again, I believe that it should have been considered. They did the right thing. In the affidavit, Juror 785 related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers questioned the ex-husband about the posts, offered to reinstate restraining orders Juror 785 had against him, and speculated that the Murdaughs probably got to the ex-husband when he called Juror 785 on the morning of the verdict. Juror 785 asserted Hill asked her whether she and the other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. She also stated that before Murdaugh testified, Hill told the jurors not to be fooled by the evidence Murdaugh's attorneys presented. Rhonda McElveen, I mean, that in and of itself on its face, as I've said from the beginning, even if it was only what Becky Hill did with Egg Lady juror, is enough to get a new trial. You remember how she was called into chambers? Maybe they'll discuss it at length in here. And questioned by Judge Newman about all of this stuff, and then she was just dismissed. It was crazy. McElveen. What did I say? McElveen. Isn't that what I said? Thanks, Elizabeth. Rhonda McElveen, the Barnwell County Clerk of Court who assisted Hill with the trial, testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house, and a guilty verdict would be the best way to sell books. McElveen testified that after hearing Hill had given a juror a ride home, McElveen counseled her that it was inappropriate. And while Hill admitted she gave the juror a ride, she claimed the bailiff was with them and they did not discuss the case. It's egregious. Footnote 5, which reads, at the hearing, Hill denied giving the juror a ride home. Although McElveen did not hear Hill say anything inappropriate to the jurors, she stated that Hill made comments to her, staff, and media members strikingly similar to those jurors Z reported, such as advising them not to be fooled by Murdaugh's attorneys and to look at Murdaugh's actions and movements while he testified. Finally, McElveen testified that Hill seated a writer with court personnel. This writer wrote the foreword for Hill's book. You just can't make it up. Next, Murdaugh called the alternate juror to testify. She described the incident in which Hill made her comments before Murdaugh put up his case, stating that while the jurors were assembled in one of the two jury rooms or were standing in the hall, Hill stood at the doorway and told them, quote, they're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. The alternate juror also testified that Hill told the jurors not to be nervous and don't be afraid to show your emotions. This is a quote, don't be afraid to show your emotions because that's what they want to see. The alternate juror related, she heard a court staff member say deliberations should not take long. but she couldn't remember who said it. Yeah, Britt says, I wonder how many other times she's done this. Chocolate Milk says, Becky got a plea deal and paid a little over $11,000. She's on probation with community service. Yeah, she was charged with perjury, and that's the slap on the wrist that she got. In its order, the post-trial court declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. It then found Hill made improper comments to the jurors on the day Murdaugh testified. For example, quote, this is an important day, or this is an epic day, and that they should watch Murdaugh's body language. The post-trial court determined Hill's denial of making these statements was not credible, finding Hill wanted to write a book, which she believed a guilty verdict would help sell. She was, quote, attracted by the siren call of celebrity, end quote. And, quote, she allowed her desire for the public attention of the moment to overcome her duty to her oath of office and her oath as a witness, end quote. I thought Justice Toll was a very good judge, and I thought she was very fair, but I did not agree with her decision. Did you like Judge Toll? She came out of retirement to do that. Next, the post-trial court found that these comments did not affect any juror's verdict. It explained Juror Z's assertions that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing Juror Z had acknowledged her statements in her affidavit that she had voted guilty due to pressure from other jurors was the, quote, more accurate statement. The post-trial court further found that Hill's comments were limited in subject and not overt as to opinion, were only heard by at most 3 jurors, and were made in a case with overwhelming and compelling evidence, and that the trial court's extensive instructions cured any effect from these comments. The post-trial court concluded that while it found Murdaugh had failed to meet its burden, his burden, to prove prejudice, any presumption of prejudice was overcome. That was really a bad decision. It therefore denied Murdaugh's motion for a new trial. Murdaugh timely appealed to the Court of Appeals. This court certified the appeal of the denial of the motion for a new trial and subsequently consolidated it with the direct appeal. Let's go to you guys for a second. Undercover Angel loves a former Chief Justice Jean Toll. Team Brittany said, yeah, no innocent until proven guilty by the clerk. She wanted to sell books. She shouldn't have said it. The only thing she's supposed to ask them is, what do you guys want for lunch? Here's the menu. What do you want for lunch? Does anybody need a break? Dumpster Fire Show says, it's a Southern thing, like some Northern folks being unable to use the alphabet. Massachusetts folks sound like injured cats to us. What do you mean, the bow thing? Thank you for your 5. And Medic Mama, thanks for becoming a member. Welcome. Roman 2, law and analysis. A, Remmer presumption of prejudice. Murdaugh argues that he was denied his constitutional right to a fair trial by an impartial jury, free from outside influences. He asserts that following Remmer versus the United States, which is a 1954 case, prejudice should be presumed from Hill's comments to the jury, and that the presumption is irrebuttable. In the alternative, he contends that the state failed to rebut the presumption of prejudice. Is Becky Hill the most hated woman in South Carolina? Midlife Mania wants to know. If you live there, let us know. The state argues the jury convicted Murdaugh because, quote, because he was obviously guilty and not because 3 jurors heard Hill's foolish and fleeting comments about his upcoming testimony. It contends that the post-trial court correctly declined to presume prejudice, and any presumption of prejudice was rebuttable. It doesn't matter if he's obviously guilty. She's not supposed to be communicating anything to the jurors and trying to influence them in any way. Her intent is irrelevant, in my opinion. Whether or not they were influenced by what she said is irrelevant, in my opinion. Whether or not they would have come to a different verdict is really impossible impossible to predict. You can't unring that bell. Yeah, we just covered that. She gave the juror a ride. That was in the page before this, I think. Oh, honey, here's Gigi gifting 5 memberships. Thanks, Gigi. You're amazing. Welcome to the new 5 members. I think you're going to like it here. We agree with Murdaugh. Prejudice is presumed from Hill's comments, and while this presumption is rebuttable, the state failed to overcome this presumption. Our federal and state constitutions guarantee a criminal defendant the right to a fair trial by an impartial jury. Citing the Constitution. 6th Amendment. No right touches more the heart of fairness in a trial than the right to an impartial jury. This right can be infringed when a third party makes improper contact with the jury, for the right is meaningful only if the jury remains free from outside influence, including exposure to evidence or information that has not been introduced during the trial. To protect the right of an impartial jury in such cases, the Supreme Court of the United States created a rebuttable presumption of prejudice, the Remmer presumption, elucidating, quote, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the jurors was harmless to the defendant. So the burden shifted to the state to prove that what Becky Hill did didn't influence the jury and didn't prejudice Murdaugh's right to a fair trial. It's kind of hard to prove a negative, right? Especially with the affidavits of the jurors and the testimony of the jurors. The United States Court of Appeals for the Fourth Circuit noted that in addition to the presumption of prejudice, quote, Remmer established a separate but related requirement that a defendant be entitled to a hearing when the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter before the jury. The Fourth Circuit established a 3-step test for considering extrajudicial contacts with the jury. Here's a quote. The party who's attacking the verdict bears the initial burden of introducing competent evidence that the extrajudicial communications or contacts were more than innocuous interventions. If this minimal standard is satisfied, the Remmer 1 presumption is triggered automatically. The burden then shifts to the prevailing party to prove that there exists no reasonable possibility that the jury's verdict was influenced by an improper communication. United States versus Cheek, which is a U.S. Supreme Court or Fourth Circuit case from 1996, cleaned up. The Fourth Circuit further provided that in determining whether the extrajudicial contact was innocuous or whether it triggered the presumption, the court considers whether there was 1, any private communication, 2, any private contact, 3, any tampering, 4, directly or indirectly with a juror during the trial, 5, about the matter before the jury. Quote, an unauthorized contact between a third party and a juror concerns the matter pending before the jury when it is of such character as to reasonably draw into question the integrity of the verdict. I mean, it couldn't be more on point. Her communications with the jury. He's going to testify. It's going to be a big day. Don't let him fool you. Don't let his facial expressions fool you. She did lots of interviews. Britt, a lot of them. She traveled with the jury to New York City to go on a morning show with them. She went on The View of Moselle with them. Hold on one second. She inserted herself into this case in ways that are unforgivable. Murdaugh's happy, though. Once the Remmer presumption is triggered, the state bears the heavy burden of proving there is no reasonable possibility that the verdict was affected by the contact. The court must examine the entire picture, including the factual circumstances and the impact on the juror. In determining whether the state met its burden of rebutting the Remmer presumption, courts consider a variety of factors such as, quote, the extent of the improper communication, the extent to which the communication was discussed and considered by the jury, the type of information communicated, the timing of the exposure, and the strength of the state's case. Citing State v. Kelly, 1998, South Carolina case, quote, relevant factors to be considered in determining whether outside influences have affected the jury are the number of jurors exposed, the weight of the evidence properly before the jury, and the likelihood that curative measures were effective in reducing the prejudice. The extent of the communication is the most important factor. Hello to Wales. Wales is in the house this morning. The world is watching. Hello, Rhea and me. Oh, please. Page B says he's in for life anyway. Oh, I love your Afro Man suit. Oh my God. I love it. He's in for life anyway. On the financial crime side, we won't be getting out either way, I think. Well, he's got 27 years in state and 40 years federal. And so he's not going to be getting out anytime soon, if ever. He pled guilty to those financial crimes. And so it's not, some people might say, why would they try him again? Why would they try him again if he's going to be in jail pretty much for his whole life anyway? It's about justice. It's about justice for the victims. It's about egg on their face. They can't not try him again, in my opinion, because it wouldn't look good. If you live in South Carolina and they decided, yeah, you know what, he's going to be in jail anyway for a really long time, so we're just not going to try him again for the murder of his wife and his son. How would you feel about that? I mean, the public's would go berserk. What do you mean you're not going to try him again? Those of you who live down there know that the Murdaugh family ruled the Low Country for almost like for a century, right? He could plead guilty, but he swears to this day that he did not do this. And his lawyers swear to this day that he did not do this. There was no third-party culprit defense used at trial because they don't know who did it. But Maggie and Paul deserve a new trial, right? This is being reversed on error. He's getting a new trial. So Jessica says, I thought you couldn't be tried twice for the same crime. If you're found not guilty. If you're found not guilty, they can't come back and try you again for the same crime. He was found guilty, and the appellate court, the Supreme Court in this case of South Carolina, has decided he didn't get a fair trial, and so he gets a new one. And it could look very different this time because He may not testify. I'm sure that'll be a game time decision. But if he doesn't testify in trial number 2, the state cannot use his testimony in trial number 1 at all. So that's going to be a strategy decision. In Parker v. Gladden, the Supreme Court recognized the extreme prejudice inherent in statements concerning the matter at trial when made by an officer of the court. Footnote 6. I know that the Supreme Court opinions are always single space, but it makes it hella hard to read on a screen. Footnote 6 says the Supreme Court did not apply the Remmer analysis. And this is a case from 1966. There, a bailiff who oversaw a sequestered jury during an 8-day trial stated to a juror in the presence of other jurors, quote, "Oh, that wicked fellow, petitioner, he is guilty." The bailiff also told another juror, quote, "If there's anything wrong in finding petitioner guilty, the Supreme Court will correct it." At least one juror or alternate overheard the statements. In rejecting the state's argument that no prejudice was shown, the Supreme Court explained this argument overlooks the fact that the official character of the bailiff as an officer of the court, as well as the state, beyond question carries great weight with a jury which he had been shepherding for 8 days and nights. Although the Supreme Court noted the 26-hour jury deliberations and one juror's testimony, she was prejudiced, also supported the trial court's finding of prejudice. It held that, quote, "The unauthorized conduct of the bailiff invokes such a probability that prejudice will result that it is deemed inherently lacking in due process." It further recognized that, quote, "It would be blinking reality not to recognize the extreme prejudice inherent in such statements that reached at least 3 members of the jury and 1 alternate." However, not all comments by officers of the court are prejudicial. In Green, a juror asked a bailiff, quote, "What would happen in the event of a deadlock?" And he responded, "The judge would likely give them an Allen charge and ask if they could stay later." Footnote 7, Allen versus the United States. I don't think they're going to tell you what an Allen charge is, so I will. It's also called in some states a dynamite charge. We saw it in the Karen Reed trial, number 1. When a jury comes back and tells the court or the judge that they're deadlocked, hopelessly deadlocked, the final push will often be an Allen charge or a dynamite charge, which judge instructs the jury and tells them, "Listen, jury, you were picked for a reason. You have spent so much time listening to this trial and paying attention and taking notes, and you are so well versed in this case that there is no jury that could make this determination better than you. So go on back there, give it another college try, listen to each other, try to understand each other's opinions, and just try one more time to reach a consensus." Judge Cannoni did that in Karen Reed's first trial. It didn't work, and they still were hopelessly deadlocked. She didn't poll the jury, and so that was the issue there on the appeals. Karen Reed did not get a new trial. I mean, she did not have... The argument there was double jeopardy, so it was a completely different issue. But Judge Cannoni did give the jury the Allen charge, and they still were deadlocked, and that resulted in a mistrial. And then there was trial number 2, as you recall, because we were there. We saw that film twice. While the Court of Appeals held the state overcame the Remmer presumption, this court held the bailiff's comments did not trigger the presumption. We explained that our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. As the Fourth Circuit recognized, quote, there is a split among the circuits regarding the issue whether the Remmer presumption has survived intact following the Supreme Court's decision in Smith v. Phillips and U.S. v. Olano. Note 8, which reads, in both Phillips and Olano, the Supreme Court noted the case's procedural postures informed the outcomes. And then explains why. This case is distinguished. Where are we? In Phillips, the Supreme Court declined to impute bias to a juror who applied for a job in the prosecutor's office during Phillips' trial. In reversing the grant of federal habeas relief, the Supreme Court declared that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. The court explained that due process does not require a new trial every time a juror has been placed in a potentially compromising situation. Instead, due process necessitates a jury capable and willing to decide the case solely on the evidence before it, and a trial judge ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. In Olano, the Supreme Court considered whether the presence of alternate jurors during jury deliberations was a plain error that the Court of Appeals was authorized to correct under the Federal Rule of Criminal Procedure 52B. Noting the alternate juror's presence was not the type of error that affected substantial rights, independent of its prejudicial impact. The court found no reason to presume prejudice. It explained there may be cases where an intrusion should be presumed prejudicial, but a presumption of prejudice as opposed to a specific analysis does not change the ultimate inquiry. Did the intrusion affect the jury's deliberations and thereby its verdict? Neither Phillips nor Olano expressly overruled the Remmer presumption. Indeed, in Olano, the court specifically recognized that prejudice should be presumed from certain intrusions, not just from alternate jurors who have been properly instructed not to deliberate, sitting in on the deliberations of a jury. The Fourth Circuit rejected the argument that the Supreme Court overturned the Remmer presumption of prejudice attached to extrajudicial communications with the jury, declaring the presumption remained alive and well in the Fourth Circuit. The Fourth Circuit explained the Remmer presumption applies in cases where the danger is not one of juror impairment or predisposition, but rather the effect of an extraneous communication upon the deliberative process of the jury. Thus, the distinction between internal and external jury influences is critical because, unlike external influences, which necessitate a thorough judicial inquiry, no such obligation is imposed with regard to an internal jury influence. Let's go to you guys for a second. Thanks, Fallen Hero, for your super sticker. Deborah, thanks for coming to New Member. And Gigi's here, and she says, woohoo, thank you, Melanie and the Cupcakes, for the well wishes. Who would have thought you needed two shoulders watching on TV in bed? Oh, I'm sorry. I hope you're getting better from your shoulder replacement. And I hope you get better soon. We're sending you all the healing vibes. For those of you who are just tuning in just now, later on, rewind and go back to the beginning because all of your questions will be answered. Julie, yes, Becky did get the egg lady juror thrown off the jury. We discussed that a little while ago, and it was in the beginning of the opinion. They may talk about it some more. Medic Mama says, I think the jury should stay together completely and more than one person should be present when anyone is around the jury. I mean, there's a lot of things that Becky Hill did that they may not even mention in this opinion, but wasn't there some chatter about her, going into the bathroom with one of the jurors all the time and like having like whispery conversations at the site view when they went to Moselle. And just really, really, in my opinion, egregious stuff. Everything that she said to the jury that we've already talked about. Oh, big day. He's going to be testifying today. Don't let him fool you. It's enough. It's enough. It's tampering with the jury. It's jury tampering. It's enough for a new trial. People may not like it. You may think he's guilty as hell, but he's entitled to a fair trial. And you can't go back and say, and the state tried this argument. They tried so hard. It didn't affect the verdict. They would have found him guilty anyway. There was so much evidence against him. He's totally guilty. Everybody knows it. It doesn't matter. What she did was highly improper. And the fact that she just got a little slap on the wrist is outrageous. Yeah, she let the press come in and take pictures of the evidence. She gave them tours of the courthouse. It was crazy. She was looking for fame. She was looking to sell a book. And then people were defending her, but she self-published it. She's not really making any money. Not the point. Again, it's not the point. It was improper contact with the jury. Egregious. Maybe it'll prevent other clerks of court and other people who come into contact in the courthouse with the jury from doing this in the future. But as T.C. Malin says, we have to protect the rights of the monsters for those rights to be there for us. Here we go. Moving on. I'm not going to read every single case citation and every single comment in parens because I'll just scroll through it slowly if you want to, but let's just hit the salient points here. This whole paragraph talks about other cases and why they differ or how they could be the same. And that's what Supreme Courts do. It's all about case law. It's all about distinguishing case law that exists or finding why it fits into the bucket of another case and why they're deciding what they're deciding. And they go through all of their reasoning. And some people find it very boring and some people find it very interesting. So if you are one of those who needs to read every single word, I'll scroll through it slowly enough that you can come back and screenshot it for later. Our decision in Green 2 did not deviate from Remmer or its Fourth Circuit progeny. Adhering to Remmer, we held only that the facts of the case did not warrant applying the presumption while leaving in place the Court of Appeals holding that the trial court must follow the Remmer procedure when it learns of an allegedly improper contact with the juror. The Fourth Circuit has long recognized that certain kinds of extrajudicial contacts may amount to nothing more than innocuous interventions that simply could not justify a presumption of prejudicial effect. We acknowledge that this court has not always employed the Remmer presumption when it's considering external influences on the jury. In Kelly, an appellant asserted that the trial court erred in denying his motion for a mistrial when a capital case juror shared a pro-death penalty pamphlet in the jury room during the penalty phase of the trial. Because the appellant framed the issue on appeal as the denial of a mistrial, the court noted that, quote, in order to receive a mistrial, the defendant must show error and resulting prejudice, and held the appellant failed to show prejudice. We did not discuss Remmer. Going on to discuss more cases. Cases where they didn't use Remmer. And here we go. We clarify today that when faced with a third party's improper contact with a juror, our courts should follow the Fourth Circuit's three-step analysis as set forth in Cheek. And one, require the defendant to meet the initial burden by presenting evidence that contacts were, quote, more than innocuous interventions. 2, if this minimal standard is satisfied, recognize the Remmer presumption is triggered automatically. And 3, shift the burden to the prevailing party to prove that there exists no reasonable possibility that the jury's verdict was influenced by an improper communication. Under this framework, we turn to the facts at hand. First, we must determine which comments Hill made to the jurors. The post-trial court referenced only a few of the comments the jurors testified she made. For example, this is an important day, or this is an epic day, and to watch Murdaugh's body language. The state argues the post-trial court implicitly rejected the other alleged comments as not being credible. We find this argument is without merit. Praise be. I said the same thing because Judge Toll only cherry-picked certain comments and used them in her reasoning. And because she only found some of them credible, some of them not credible, it didn't really make any sense to me. Oh, please. The post-trial court gave no indication it found the other comments not credible, nor would the record support such a finding. Indeed, the post-trial court found Hill's denial of making any inappropriate comments lacked credibility. Footnote 10. Hill's lack of credibility during the hearing on Murdaugh's motion for a new trial is further evidenced by her recently guilty plea to perjury, stemming from the hearing for her denial of allowing members of the press to view the sealed exhibits. She's a liar. Guess they prosecute for perjury in South Carolina. The post-trial court made no distinction regarding the comments it referenced in its order and the remaining comments that are in the record. The post-trial court, in fact, found credible Juror Z's affidavit statement concerning pressure from other jurors. This same affidavit included Juror Z's recollection of Hill's comments, quote, not to be fooled by the evidence presented by Murdaugh's attorneys and Hill's instructions to watch Murdaugh closely, quote, look at his actions and look at his movements. The state offers no rationale for finding part of the affidavit credible while rejecting the portions that are damaging to the state's case. Juror Z's recollection of Hill's comments were consistent with Juror 785's affidavit testimony that Hill told the jurors not to be fooled by the evidence Murdaugh's defense presented. Juror Z's recollection is also consistent with the alternate juror's testimony concerning Hill's comments. Quote, they're going to say things that'll try to confuse you. Don't let them confuse you or convince you or throw you off. Footnote 11. Which reads, the post-trial court did not make a finding on the alternate juror's credibility. These comments were also strikingly similar to the comments Hill made to McLevine, other staff members, and the media went away from the jury. Furthermore, Hill's attempts to insert herself into the jury's deliberations through these comments was in line with her stated desire for a guilty verdict to sell more copies of the book she planned to write. Her meddling in events around Juror 785's dismissal, and her self-aggrandizing conduct throughout and after the trial, from granting favors to media members, such as allowing them to view the sealed exhibits and sitting a writer with court staff in the courtroom, to granting interviews. As the post-trial court found, Hill was attracted by the siren call of celebrity. One of the best quotes ever. And, quote, allowed her desire for the public attention of the moment to overcome her duty to her oath of office. We have no reason to find Hill did not make all of the statements the jurors reported. Therefore, we hold Murdaugh established Hill made the comments that the day Murdaugh testified was epic or important, and urged the jurors to not be fooled, confused, thrown off, or convinced by Murdaugh, and to watch Murdaugh's body language closely. Next, we must decide whether these comments were, quote, more than innocuous interventions and of such a character as to reasonably draw into question the integrity of the verdict. Hill's statements were more comparable to those of the bailiff in Parker than those of the bailiff in Green. Like the bailiff's statements in Parker, Hill's comments attacked the defendant's character and credibility, which certainly were matters before the jury. So in Parker, the bailiff told the jurors, "Oh, that wicked fellow, he's guilty." And in Reyes, stating, quote, "The credibility of a witness is exclusively for the jury to decide." Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility. In fact, by urging the jurors not to be fooled or convinced by Murdaugh's defense, Hill essentially implored the jurors to find him guilty, the ultimate issue in the case. I remember when we first initially, I'm breaking from the document for a second. When we first initially started talking about this case, so many viewers, people, were wondering why the jurors didn't report it, why the jurors did not report Becky Hill talking to them and making comments to them and telling them these things. And at the time I said to you, and I still believe this, is that how would jurors who have never served on a jury before know that it was improper for Becky Hill to do that? How would they know? Right? Hang on one sec. You can just come over and wave if you want. I have a kid that brought me breakfast. Hello.
Good morning. I don't know if they've ever seen me before.
I don't know. I don't think they have seen you before. You've been away. How would the jurors know that that was improper? They think that this woman, Becky Hill, runs the courtroom, that anything that she did would be totally okay. Right? They would think that she would be the one following the rules and that she was allowed to have contact with them. They wouldn't know. And people got angry, like, well, why didn't the jurors report it? It took the defense team to find this out. I don't remember how exactly they found it out. If one of the jurors came to them, but I remember Harpootlian saying that they had to go down dirt roads to knock on doors and that some of the jurors didn't even want to speak to them. And that's what I would say to you, is that you guys watch a lot of trials, right? So you know that it's improper and that bailiffs are not supposed to be telling you that a guy is guilty and whatnot. But the people who have served on a jury for the first time, they don't know those things. How would they know? Right? Trevor Exennial says, "It was my first trial and I was never on LawTube, so I would have no idea if it was," she says. So you can't blame the jurors, because how would they know? Even Hill's seemingly innocuous comments that the day Murdaugh testified was an epic or important day became nefarious when considered with her other comments, insinuating that there was something unusual and suspicious about his decision to testify. In contrast, the bailiff statements in Green, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. Therefore, we hold Murdaugh met the minimal standard of showing that the extrajudicial communications or contacts were more than innocuous interventions. And the post-trial court erred as a matter of law in refusing to impose the Remmer presumption. Our following consideration is whether the state met its heavy burden of proving, quote, "There is no reasonable possibility that the verdict was affected by Hill's comments." As stated above, the post-trial court analyzed the evidence before it by erroneously imposing the burden of proof of prejudice on Murdaugh. Furthermore, as Murdaugh argues, the post-trial court erred in considering testimony from the jurors about whether Hill's comments affected their verdict because the testimony violated Rule 606B of the South Carolina Rules of Evidence. And here it is, Rule 606B. Limits the testimony a juror may give on the issue of prejudice. This rule provides, quote, Upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent or dissent from the verdict or indictment, or concerning the juror's mental processes in connection therewith, except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes, right? So they're not allowed to inquire as to what happened in the jury room, what were your discussions like, what did this juror say, what did that juror say, only whether there was some outside influence that affected the jury. I don't know. I'm like, the chat is totally distracting me. Like, there's some conversation going on that I'm not involved in here. Some conversation about dogs. I don't know what you guys are talking about, but like, what dog? Is there a dog? Is there a dog that's going to be mentioned? Is a dog going to be mentioned in this decision opinion that I haven't gotten to yet? Hang on. In interpreting court rules, this court applies the same rules of construction used to interpret statutes. Thus, if a rule's language is plain, unambiguous, and conveys a clear meaning, interpretation is unnecessary and the stated meaning should be enforced. We must consider not only the particular clause in which a word may be used, but the word and its meaning in conjunction with the purpose of the whole rule and the policy of the rule. In addition, when a South Carolina rule is substantially the same as its federal counterpart, we may consider federal cases in interpreting the rule. My cursor's in the wrong place. And then they go on to discuss Federal Rule of Evidence 606B. And the legislative history of that rule. Let's get to the facts of this case. We find that the plain language of Rule 606B authorizes jurors to testify about improper extraneous comments by a third party, but not on the comments' effects on the juror's deliberative process. While, as the Fourth Circuit recognized, Rule 606B at times makes it more difficult to determine whether a new trial is warranted, sound policy supports the rule and outweighs any inconvenience or difficulty the rule imposes. The state must meet its burden of rebutting the Remmer presumption without exceeding the limits of the rule. Footnote 12, we recognize that in Atty, this court held that the affidavits and testimony from jurors describing whether another juror's premature deliberations affected their votes were admissible because premature deliberations may affect the fundamental fairness of the trial. We hereby overrule Atty to the extent this case condoned the use of testimony about the juror's mental processes in reaching its verdict. They outright overruled the case. What did I miss? Where is it? The state contends Murdaugh cannot complain about the post-trial jury questioning. The state contends that Murdaugh cannot complain about the post-trial court questioning Juror Z regarding her affidavit because Murdaugh submitted the affidavit to the post-trial court with his motion for a new trial. We disagree. The purpose of Rule 606B is to preserve the sanctity of the jury room, protecting the jury system and the citizens who make it work. This right was not Murdaugh's to waive. Thus, the portion of Juror Z's affidavit in which she disclosed her mental process in reaching her verdict was inadmissible. The post-trial court erred in questioning her about that portion of the affidavit, and the post-trial court should not have considered that portion in ruling on the new trial motion. Hold on. Deborah Anderson. Deborah Ann says, Becky Hill got off easy. She should have been given jail time. Anyone else would have been given a jail sentence for committing perjury. Everyone hit the like button while we're here. Kate Williams says, I wonder if Becky lost her state pension. I can't find anything that confirms that she did. I hope she does with this ruling. I don't know if she did or not. Oh, thanks, 20th Century Fox, for hanging out with me for 20 months and for your very nice compliment. I appreciate you so much. We also hold the post-trial court erred in finding a lack of prejudice because Hill's comments were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors, and were made in a case with overwhelming and compelling evidence. We reiterate, the burden is on the state to rebut the presumption of prejudice. First, the post-trial court erred in finding Hill's comments were limited in subject and not overt as to opinion. Hill clearly advised the jurors to find Murdaugh and the evidence he presented not credible, and essentially urged them to render a guilty verdict. Hill's position as the Colleton County Clerk of Court, an officer of the court who managed the trial and was the primary caretaker of the jury, amplified the impact Hill's comments had on the jury. Hill was elected by the very people who make up the Colleton County jury pool. Well, there's the answer to some of the questions that I saw in the beginning, whether she was elected or appointed, and she was elected. Next, the limited number of jurors who acknowledged hearing Hill's improper comments did not reduce their prejudicial effect. As the Supreme Court explained, a criminal defendant is entitled to be tried by 12, not 9 or even 10 impartial and unprejudiced jurors. In addition, in the context of a jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden of proving a lack of prejudice. The state certainly produced considerable evidence here, and arguably reasonable minds may debate whether the evidence here was overwhelming. In the situation before us, notwithstanding the strength of the prosecution's case, the state is unable to overcome the presumption of prejudice. The state's case rested largely on circumstantial evidence, and Murdaugh's credibility was a key component of his defense. Hill's repeated comments challenging Murdaugh's credibility directly undermined that defense. Hill's egregious, improper jury interference went to the heart of the case and unquestionably was intended to push the jury to a guilty verdict. I happen to agree. Even if it was one juror, that's one juror too many. Oh, this is pretty bold. The breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. Breathtaking. Reminds me of the Seinfeld episode about the baby. When are you going to see the baby? When are you going to come see the baby? When are you going to come see the baby? And the pediatrician, and they're in the Hamptons. I just saw this episode the other night because it was on recently. They're in the Hamptons, and George's girlfriend that he brings goes topless sunbathing, and they all see her topless except for George. And then she decides to walk in on George when he's getting changed, and he's like, "It was cold, the pool. I was in the water. It was cold." Anyway, back to the baby. The pediatrician called Elaine breathtaking. He said, "Oh, Elaine, you're breathtaking." And then also the baby, when they went to see the baby, are you going to see the baby? And they looked at the baby, and apparently the baby was not very good looking. And then the pediatrician called the baby breathtaking, and then Elaine couldn't get over it. Shrinkage. It was shrinkage. It was breathtaking. The baby's breathtaking. Elaine was breathtaking. And it's a very funny episode, and Seinfeld references are always welcome here. I was in the pool. Finally, we hold the state has not met its burden of proving the trial court's instructions to the jury cured any prejudice arising from Hill's comments. Generally, an instruction to disregard incompetent evidence is deemed to have cured the error. Moreover, jurors are presumed to follow the laws instructed to them. Here, the trial court gave the standard instructions and admonishments to the jury, none of which provided guidance on what to do when the Colleton County Clerk of Court, an officer of the court, made comments disparaging Murdaugh's credibility and urging the jury to reject his defense. The trial court never had the opportunity to even attempt to cure the prejudicial effect of Hill's comments because they did not come to light until months after the trial. Right. There was no way that they could give a curative instruction, or that Judge Newman could give a curative instruction, because he didn't know that it happened. Nobody did. If we were to accept the proposition that standard charges could cure such prejudice, then no defendant would be entitled to relief when improper extrajudicial information reaches the jury's ears, regardless of its content or context. Our federal and state constitutions simply cannot countenance such an assault on the right to a fair and impartial jury. In summation, Murdaugh met his initial burden of establishing Hill's comments to the jury were more than innocuous interventions, triggering the Remmer presumption of prejudice and shifting the burden to the state. The state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the jury's verdict was influenced by these highly improper comments. They're telling us everything. They're telling us everything that they feel about Becky Hill. Accordingly, we hold Murdaugh's right to a fair trial by an impartial jury was violated, and the post-trial court erred in denying his motion for a new trial. There it is. There it is. Frozen says, how often does this happen in smaller cases? Well, we don't know. If it's not reported, we don't know. But now that this is becoming more public, maybe maybe they'll instruct jurors differently. Maybe people who would sit on a jury might know that it is improper, and that if this does happen, they will report it. Thanks, Rhonda, for being here for 5 months. She says, love being here. Appreciate you. Thank you. Thank you so much. Now we turn to the evidence of Murdaugh's financial crimes. But before we do that, thoughts, questions, comments, concerns. They shouldn't have to give that instruction. Clerk of courts should know their roles. And also, every trial that we watch, and I don't know because I didn't watch this with you guys, so I can't remember all the way back to 2023. Every time the jury comes in the room, the judge asks the same question. Did you do any outside research? Did anybody approach you about this case? Did you discuss this case? I don't remember if Judge Newman did that. But again, they may have thought the clerk was an exception because she's an officer of the court. She should know what to do. Oh, Connie tried, and she can't. Can't even download Miss Becky's book on Audible either. Oh, bummer. Maybe we'll have to do a dramatic reading one day. Read a chapter a day until we get through it. If you guys are into it, because I've got it. Got it right here. I knew it was going to be worth something someday. A lot of Seinfeld talk. The bakery scene with the old woman and the bread in Seinfeld. The marble rye? Are you talking about the marble rye? Makes me giggle so hard I could wear Depends. Thanks, P. Lola. It's always funny to me. It's always funny to me. I don't know. Is it like New York humor, though? Do some people not get it? Is it too like New York? No soup for you. And can you spare a square? Will never get old, says the Lady Wags. Drama must remain on the stage. Back to Becky Hill. Not to mention she left evidence photos laid out for others to take pictures of. Yeah, you mean the media? You gotta say the baby. B. Crumb says Kramer could not hide his reaction to the baby. Kramer couldn't hide his reactions to everything. I mean, his face had subtitles. And his physical comedy was also so good. The way he could fall. He was always falling and tripping over things. The Caleb Flynn trial, Lauren Gillespie, has been pushed until September. So I've done a couple of shows on it already, but it's not happening right now. It has been pushed into September. And so, in my opinion, that was enough. That was enough. They could have stopped right there. But now they want to talk about the financial crimes and whether it was proper to allow that evidence in. And here's why. Because we order a new trial on the basis of Hill's improper influence on the jury on appeal from the order denying Murdaugh's motion for a new trial, it is not necessary that we address the evidentiary issues Murdaugh raises on appeal from his convictions and sentences. We elect, however, to offer the trial court on remand the following guidance regarding the admissibility of evidence of Murdaugh's financial crimes. Footnote 13, which reads, in addition to Murdaugh's challenge to the trial court's decision to admit evidence of his financial crimes, Murdaugh appealed the trial court's decision to, 1, allow the state to question a witness on redirect examination about the witness's knowledge of Murdaugh's financial situation, 2, admit evidence of firearm and tool mark analysis expert testimony, 3, admit evidence of 4 firearms seized from Moselle, 4, admit evidence of a blue raincoat collected from the home of Murdaugh's mother and gunshot residue expert testimony related to that raincoat, 5, allow the state to question Murdaugh on cross-examination as to the reasons he did not reveal until trial his presence at the kennels on the night of the murders, and 6, admit evidence of an iPhone demonstration during the state's rebuttal case. We saw an iPhone demonstration, didn't we? In open court in the Karen Reed case? Didn't Ian Whiffen do like a live, well, I don't know if it was on an iPhone or his laptop, but didn't he do like an exemplar Google search and then go back to the tab to see what time it's said or something like that? He did a real-time demonstration of something Whiffen did in court, right? Remind me. Hold on. At the time of the trial, Murdaugh had been accused of and indicted for numerous financial crimes. During his testimony before the jury, Murdaugh admitted he committed the financial crimes, although he had not at the time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to a concurrent 27 years in state prison and 40 years in federal prison. Concurrent means they run at the same time, and therefore, he's still going to be in prison for 40 years, approximately, give or take. The state sought to admit evidence of these financial crimes during Murdaugh's murder trial for the purpose of showing his motive for committing the murders. The state filed a pretrial motion in which it argued the evidence demonstrated, quote, Murdaugh accrued substantial debts over a period of years, and to cover those debts began engaging in illicit financial crimes involving the theft and misappropriation of money from his clients and his own firm. He was also disbarred, as he well should have been. The state emphasized that several series of events unfolding in the weeks and days leading up to the murders threatened to expose Murdaugh's financial crimes. The state wrote in its motion, quote, all of these factors start to converge on June 7th, 2021, the date of the murders. The state explained its motive theory. Quote, the murders served as Murdaugh's means to shift the focus away from himself and buy himself some additional time to try and prevent his financial crimes from being uncovered. The state also stressed Murdaugh's attempts to cover his financial misdeeds after the murders to support its theories of motive. To support its theory of motive. Yes, Dave Matthews' neighbor. Tell me you're late without telling me you're late. That was probably the third time that we talked about it. I'll forgive you for being late. Your late note should be submitted to the office no later than noon Eastern time. So yeah, he's going to be 40 in 40 years anyway. Murdaugh filed a memorandum arguing the financial crimes evidence should be excluded under Rules 402, 403, and 404 of the South Carolina Rules of Evidence. The trial court conducted a lengthy pretrial hearing, but declined to rule on the admissibility of the financial crimes evidence at that time. During various breaks in the course of the trial, the state presented the testimony of 8 witnesses regarding Murdaugh's financial crimes outside the presence of the jury. After hearing this testimony and the arguments of both sides, the trial court found, quote, all evidence of financial crimes that may likely have led to a motive or lend itself to motive for the crime committed was admissible. The trial court stated the jury was entitled to consider whether the apparent desperation of Mr. Murdaugh because of his dire financial situation, threat of being exposed for committing the crimes for which he was later charged with, resulted in the commission of the alleged crimes. The trial court also found, quote, this evidence of other crimes is admissible and its non-propensity, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground than the specific charge. The trial court found the evidence had sufficient probative value that was not substantially outweighed by any danger of unfair prejudice. I disagreed with that as well. The trial court issued a written order setting forth its ruling. The state then presented testimony to the jury from the 8 witnesses who testified earlier, along with 2 additional witnesses. Footnote 14. The 8 witnesses who testified outside the jury's presence were Jeannie Seckinger, the chief financial officer of Murdaugh's law firm, Michael Gunn, a principal in Forge Consulting, LLC, attorney Chris Wilson, Murdaugh's friend and his co-counsel in several cases, Jan Malinowski, who succeeded Russell Lafitte, Murdaugh's co-defendant and co-conspirator in the financial crimes, as president of Palmetto State Bank, Michael Tony Satterfield, the son of Murdaugh's former housekeeper, Gloria Satterfield, Carson Burney, a forensic accountant in the Attorney General's office, attorney Mark Tinsley, Murdaugh's former friend and opposing counsel in a civil lawsuit involving a 2019 boat wreck in which Murdaugh was personally named as a defendant, right? That's the one where Paul, it was alleged he was driving the boat, and the wreck in which the young girl was tragically killed. And attorney Ronnie Crosby, Murdaugh's former law partner. The additional witnesses were Annette Griswold, Murdaugh's former paralegal, and Natasha Moody, a consumer resolution associate at Bank of America. That was a long footnote. Through these witnesses, the state proved Murdaugh committed wide-ranging financial crimes over numerous years in several general categories, including the following. 1, Murdaugh stole money from his clients by billing personal expenses to them under the guise of those expenses being costs associated with their cases. That's like ethics 101. It's like ethics 101. You don't steal your client's money. Number 2, Murdaugh stole money from his law firm by instructing law firm employees to make checks payable to Palmetto State Bank, whose then chief executive officer, Russell Lafitte, enabled Murdaugh to convert the funds for his personal use. 3, Murdaugh stole money from his clients and his law firm by instructing law firm employees to make checks payable to Forge, a fake account Murdaugh created to imitate the legitimate Forge Consulting LLC firm that Murdaugh then deposited and used for personal expenses. And 4, Murdaugh stole money from Tony Satterfield by filing an insurance claim in relation to his mother, Gloria Satterfield's death, and collecting the insurance proceeds for personal use instead of providing the proceeds to Tony and Gloria's other son. Do you think that prejudiced the jury at all into thinking, well, he did all that stuff. He probably killed Maggie and Paul. It could be considered more prejudicial than probative, in my opinion, as I thought. Let's see what the Supreme Court has to say about it. The state also presented evidence to the jury that Murdaugh's years of stealing money in these ways was about to be exposed. For example, law firm employees testified they asked Murdaugh on at least 2 occasions in the weeks leading up to the murders about discrepancies in his financial disbursement documents in individual cases. Jeannie Seckinger, the firm's chief financial officer, testified that she confronted Murdaugh on the morning of the murders, stating, quote, "I have reason to believe that you received attorney's fees in a certain case directly to you, and you need to prove to me that you did not." Other evidence indicated Seckinger was referring to a $792,000 in missing attorney's fees the firm was supposed to receive from Murdaugh's co-counsel, Chris Wilson. I remember this from the Hulu miniseries. Did you guys watch the Hulu miniseries? It was really good. It was really good. Jason Clarke, the actor who played Alex Murdaugh, was on point. Everything, his mannerisms, the voice, it was great. And when I told you that I watched the movie Chappaquiddick recently, in which he played Ted Kennedy, same actor, that's his thing. Like he can study and create characters based on real people, and that's a very difficult skill. It's a very difficult skill. He was amazing, I thought. And Patricia Arquette is amazing in every single thing that she does. So it was good. And I remember this exact scene where she confronts him about the money. And in my opinion, having learned about this, and it was the same day as the murders, right? Well, this was 2 occasions, and the morning of the murders, right? On the morning of the murders, she confronted him. She was like, "Alec, there's like $792,000 missing. Where is it?" And a jury could believe that Alec then murdered his wife and son to pull focus from the missing money, because then after the murders happened, they didn't really bother Alec about the money because they're like, "Oh, he's going through too much. Going through too much." The state also presented evidence that Mark Tinsley, the attorney representing the family of the young woman who died in the boat wreck, Mallory Beach is her name. Mallory Beach. Thank you. I couldn't think of it. I remember doing a whole show on the settlement. That was years ago too. Thank you, Connie Stefanski. Rest in peace. Rest in peace, Mallory Beach. That Mark Tinsley had scheduled a motion hearing for 3 days after the murders, in which Tinsley sought to compel Murdaugh to disclose his detailed financial records. Right. That happened to be adjourned also because Alec was in mourning, right? So it bought him some time. Murdaugh challenges the admissibility of evidence of his financial crimes under Rules 401 and 402, 403, and 404B. See Rule 401. Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Rule 402. All relevant evidence is admissible except as otherwise provided. Rule 403. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Rule 404B, evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewith. It may, however, be admissible to show motive. As to Murdaugh's relevance objection, the state argues that because Murdaugh was charged with murdering his wife and son, seemingly inexplicable conduct when standing alone, it was important that it offer evidence to explain why he did it. The state also argues that Murdaugh himself placed the issue of motive front and center through his own actions by suggesting to officers who arrived at Moselle on June 7th that the killer's motive stemmed from the boat wreck. Oh my gosh, Cousin Eddie. Oh yeah, Cousin Eddie setting up his own shooting. Will Cousin Eddie testify this time? I remember when that happened in real time, that unfolded in the news, and that was wild. And I thought right away, I'm like, oh, he must have set this up. And he turns out he might have. Cousin Eddie. We agree with the state that evidence of Murdaugh's financial crimes made the state's theory of motive more probable. Thus, we find the trial court acted within its discretion in finding that the financial crimes evidence was relevant under Rule 401 and admissible under 402. The more difficult question is whether the trial court should have excluded all or some of the financial crimes evidence pursuant to 404B or 403. We address this question as two distinct categories of issues. The first of these categories, whether the trial court should have excluded all of the financial crimes evidence, is a point on which not all members of the court would have ruled the same way had we been on the trial court. So the first part of the case about whether Becky Hill, of this decision, about whether Becky Hill improperly tampered with the jury requiring a new trial, they all agreed on. Here is where the Supreme Court had a little bit more difficulty and had some differing opinions. We each agree, however, that this was a decision within the discretion of the trial court under the facts and circumstances that existed in Murdaugh's murder trial. As to the second category, we will address whether the trial court should have restricted the extent to which the state was allowed to present this evidence. That is, whether the trial court should have excluded some of the evidence. We unanimously hold the trial court allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive, which gave rise to considerable danger of unfair prejudice and therefore should have been excluded. Far too long and far too deep. As to whether the trial court should have excluded all evidence of Murdaugh's financial crimes under Rules 403 and 404B, we have discussed the principles applicable when a trial court is asked to exclude evidence of other crimes in numerous cases, and no further elaboration of those principles is necessary here. See, for example, evidence of other crimes, wrongs, or acts may not be admitted for purpose of proving the character of a person in order to show action in conformity therewith. Propensity evidence is admissible if offered for some purpose other than to show the accused as a bad person or he acted in conformity with his prior convictions. The state must show a logical connection between the other crimes and the crime charged, such that the evidence of other crimes reasonably tends to prove a material fact and issue. Even if prior bad act evidence falls within an exception, it must be excluded if its probative value is substantially outweighed by the danger of unfair prejudice to the defendant. And that will differ in every single case. Every single case will have different considerations. Do you think a jury could be prejudiced by hearing all of those things that Alex Murdaugh is alleged to have done with regard to stealing client money, opening fake accounts, paying himself, defrauding his clients, would a jury find him more likely to have committed the murders of his wife and son? Was it too prejudicial? Oh, please. There's a leaf blower convention going on outside my window. Can you hear it? As to Rule 404B, the difficulty lies in the application of these principles to the facts and circumstances of any individual case. Here, the trial court correctly understood the applicable principles of law and thoughtfully applied those principles to the facts and circumstances before it. The trial court explained its view of the logical connection between the financial crimes and Murdaugh's motive. The state's argument that it presented a valid theory of motive and Murdaugh's response to that the state's argument that it presented a valid theory of motive and Murdaugh's response that the, quote, fabricated motive theory is illogical, implausible, and not supported by the evidence was not a dispute for the trial court to resolve by making this evidentiary ruling. That was for the jury. The trial court's job was to determine in its discretion whether the state's theory of motive was reasonably plausible, and if so, whether the evidence the state presented could reasonably support the theory. We agree with the state that under the facts and circumstances in existence in Murdaugh's first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404B, agreeing that it could go to motive. As to Rule 403, the trial court balanced the probative value of the evidence against its potential for unfair prejudice and concluded that the probative value was not substantially outweighed by any unfair prejudice. The trial court specifically found Murdaugh's commission of the financial crimes does not suggest to the jury that the defendant has a tendency to commit murder. As we will discuss below, we find considerable unfair prejudice in allowing the state to go as far and deep into detail as it did. However, we hold the trial court acted within its discretion in admitting some evidence of Murdaugh's financial crimes. We emphasize, however, the trial court should have limited the state's presentation of this evidence. We illustrate this point with an example from the direct examination of Tony Satterfield. So here, I'm breaking from this for a moment to say, they are giving the next trial court some guidance on what they think will be or should be permissible at trial number 2. And this is part of Tony Satterfield's direct examination. It's Gloria Satterfield's son, housekeeper. State, why were you the personal representative and not your brother? Tony said, because my brother is a vulnerable adult and he has a disability. And then the judge said, can you repeat those words for me? And then Tony said, that's my brother. He's a vulnerable adult and he's not able to function as a normal human being to deal with stuff like that. The state said he's a vulnerable adult, and Satterfield said yes. This particular testimony had zero probative value as to Murdaugh's motive for the murders and obviously high potential for unfair prejudice as it portrays Murdaugh as a man who preys on vulnerable victims. Much of the additional details the state presented as to Murdaugh's financial crimes had little or no probative value for the purpose of establishing Murdaugh's motive. The state's theory of motive centers on the point that his financial crimes were about to be exposed and he needed time. The fact he committed some of those crimes against a vulnerable adult adds nothing to the theory. To the extent many similar details may have had minimal probative value, that value is substantially outweighed by the unfairly prejudicial sympathy the jury was likely to feel toward this victim. By our calculation, the state spent a total of 12 and a half hours of actual testimony before the jury over 10 days of trial to introduce evidence related to Murdaugh's financial crimes. We are convinced the state could have effectively presented evidence to support its motive theory in a fraction of that time. So this trial in total was 6 weeks. The jury deliberated for, I think, a little less than 3 hours. And 10 days of trial. So trial number 2 could be substantially shorter, especially if Alex chooses not to testify in trial number 2. As always, it's his decision. And yeah, he was preying on vulnerable victims 100%. But do you think that the jury, in knowing that, if you were sitting on a jury and you knew that, would would that affect your opinion of him in general and then maybe lean you towards a guilty verdict of the murders? Helena says, my heart breaks for the Satterfield boys. That steal was one of the ugliest, in my opinion. By holding that the trial court in this case acted within its discretion in admitting some evidence of Murdaugh's financial crimes, we certainly do not intend to require the evidence to be admitted on retrial. As is often the case, the facts and circumstances on retrial may be materially different from those presented in the initial trial. Thus, the trial court on remand must do, as the trial court did here, carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdaugh's financial crimes on retrial, the state must complete its introduction of that evidence efficiently, without the lengthy presentation of inflammatory details with little to no probative value that was permitted in the first trial. So they're not specifically saying what should have been allowed in, what should not have been allowed in. But it's kind of a warning to the state that if they choose to retry him, they need to be more careful and don't take so long to get that evidence out, and the inflammatory details won't be necessary. Otherwise, you might find yourself back up in the appellate courts if Alex Murdaugh thinks it in trial number 2. If it happens, it's going to happen. Would be more prejudicial than probative. It's a weighing test. Conclusion. As the Fourth Circuit declared, the Remmer presumption is alive and well. It serves to protect the right to a fair trial by an impartial jury for all defendants. Here, Hill, the Colleton County Clerk of Court, egregiously attacked Murdaugh's credibility and his defense, thus triggering the presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside of the presence and knowledge of the outstanding trial judge and superbly competent and professional counsel for the state and defense. So here, the Supreme Court of the state of South Carolina is acknowledging that the judge and both sides, all attorneys, did a great job. It wasn't your fault. You did a great job, Hill. It was all Hill's fault. It was all her fault. All her fault. Some pretty strong words for Becky Hill. Egregious. Shocking. We are accordingly constrained to reverse the post-trial court denial of Murdaugh's motion and remand for a new trial consistent with this opinion. That's it. We have no choice. We have no choice. What Becky Hill did was so egregious, so outside the bounds of decency, that her jury tampering entitles Alex Murdaugh, under the Constitution of the United States of America, to a new trial. Every defendant deserves an impartial jury and a fair trial. And Becky Hill screwed it. She screwed the pooch. Footnote 15, which reads, we commend the post-trial court, which inherited Murdaugh's motion for a new trial and was placed in the unenviable position of evaluating unprecedented jury interference by a clerk of court within the context of a murky area of law. So here, they're saying, Judge Toll, you did a great job. You did a really great job. This has never happened before. It is unprecedented that anybody any clerk of court has ever interfered with a jury ever before in this jurisdiction. And the law is kind of murky. And so, we had to overturn you. We had to reverse you. But it's okay. You did a good job. And they pin it all on the girl. They pin it all on Becky Hill. And it was a unanimous decision. Kitteridge, the Chief Justice, Few, James, Hill, and Verdon all concur. They all concur. It's rare, right? I mean, that you get a Supreme Court decision where all the justices agree. We're going to take a look at the statements that Creighton Waters and the Attorney General gave to the press yesterday in a moment. But first, let's go to some questions. Iceman, thanks for your 10. Says, Mel, if the Supreme Court didn't have the issue of Hill to deal with on this, do you think they could have or would have overturned his conviction for the overwhelming financial crime stuff? Well, they kind of told us without telling us. Would that have been enough for them to grant him a completely new trial? Maybe. They didn't have to decide it on those grounds. So it's hard in hindsight to say what they would have done had Hill not done what she did. Seems like they might have leaned that way, but there would have been a much different opinion, and they would have weighed all of the factors, and they would have talked about every single thing that was admitted with regard to the financial crimes, and they would have reasoned their decision that way. But here, they didn't really have to get there because they decided that what Becky Hill was enough to give him a new trial. And so they just gave some boundaries and some guardrails and some suggestions for what the state tried to get into evidence on the next go around. And that's a great question. Thanks for your 10. Charlie says, Karen Reed, Kelsey Fitzsimmons, Alex Murdaugh, Guilford Four, etc. How many thousands are sitting in jail? 100% innocent. Did you mean to say Edric Faust and that sort of like self-corrected? Thanks, Charlie, for tuning in from Australia. There's a lot. I would imagine that there's a lot. And those are the cases that I like to cover. Casey Paralegal says, listening while working. Love from Denver. Go Buffs. And Avalanche. That was a great game last night, wasn't it? I'm sorry to those of you whose production at work has diminished because you have me in an earbud. But I also enjoy keeping you company during your work days. Let's see what you guys have to say. Amanda says, Mr. Waters. And I every time I hear his name, I think of the way that Alex Murdaugh used to say it. Mr. Waters. Mr. Waters. Covered all the bases. Judge Newman sounded so disappointed in Alec when he had to render his verdict, and then Becky effed it all up. Veronica said, if other jurors from other trials come forward, they would have to look into those trials also. Correct? You're correct. But also, Becky Hill, didn't Becky Hill, as I recall, had a longstanding relationship with the Murdaugh family? And didn't like Alex Murdaugh greet her in court and stuff? Like he had been trying cases in that courthouse as his daddy and granddaddy had for a century. Connie Stefanski, can Miss Becky be sued to pay for the retrial since she caused this debacle? I don't think so. No. She got her punishment, and her punishment is probation. She lost her job. And she has to do some community service, I think. But a lot of you think that she should have to pay all the fees for a new trial. Yeah, Poots waving that pew-pew around was wild. It was. That was crazy town. Connie said he did prey on those Satterfield boys. Alec knew that one had a disability and the other son was doing the best he could, taking care of he and his brother. Right, but there were also a lot of other clients that he scammed too. It wasn't just them. They weren't the only ones. And Flynn says, it's all okay because he still has 40 years in prison for the other stuff. That's true. Marianne says, not sure I can go to this again. All right, we'll miss you. We'll miss you. I'm here for it. Yep, he did. He waved around that firearm, and I remember that very, very, very well. Yeah, this is interesting too. R2 RN to mom says, I believe the housekeeper probably had a stroke and Murdaugh took advantage of the situation and saw an opportunity to scam. Well, here's what happened. Apparently she fell down some steps outside Moselle. And Alex Murdaugh convinced the brothers to sue him for that under the guise of, I want to help you. I want to help you obtain some money. So why don't you sue me? And here's my buddy. He'll handle the case for you as your attorney because I can't. And I'll admit liability to the insurance company and we'll just get you guys a settlement. And he did that. He did all of it. And then he stole the money. That's what he did. But in the miniseries, it was as if he said there, he said, I'm going to tell my insurance company that the steps were defective in the miniseries. And so I don't know if this is what happened because Gloria Satterfield sadly passed away and we don't have her to tell us. In the miniseries, they were coming home from a vacation and the car was full of luggage and he had Gloria go out and carry all the luggage up the front steps. And in the miniseries, there was like a loose brick and she's like trying to carry all this luggage with her really bad back and injured neck up the stairs. And she trips on the defective brick that was loose and she falls down the stairs. And I think it had something to do with the dogs and the dogs came out. But he's a scammer. He is absolutely 100% a scammer and a thief. Does it make him a murderer? I don't know. You tell me what you think. All right, here are the statements from yesterday of Creighton Waters, the prosecutor who tried the case, and the attorney general for the state of South Carolina, speaking to the press yesterday after this decision came out. And you'll hear from the horse's mouth what they have to say about this. And maybe they'll answer some of our questions. As always, let me know that you can hear it okay. And here we go. The case died on that hill, Becky Hill. Well done, big old dog. Well done. Here we go.
Ruled in a 5-0 decision to reverse the murder convictions for Alex Murdaugh for the June 2021.
Wait a second. Maybe Channel 19 didn't turn their camera on in time. Here we go.
Ruled in a 5-0 decision to reverse the murder convictions for Alex Murdaugh for the June 2021 murder of Maggie and Paul Murdaugh. The court based its decision.
Hold on a second. Look who's here. We have a celebrity in the chat. Kathy from Gossip, Rumor, and Innuendo is here. Everyone say hi to Kathy. If you don't follow Kathy on YouTube, please do. Kathy, I'm so glad that you got your channel back. And I'm so mad that you were hacked. And I've told everyone your story. And I was really, girl, I was like sweating for you. I was so upset about this whole thing. And so I'm so glad everything worked out in the end because that must have been terrifying. I could feel your anger and fear in your post, and we love you so much. Okay, let me just rewind that again because we all had to say hi to Kathy.
Ruled in a 5-0 decision to reverse the murder convictions for Alex Murdaugh for the June 2021 murder of Maggie and Paul Murdaugh. The court based its decision on the conduct of then Colleton County Clerk of Court Rebecca Hill. As you know, this conduct involved her interactions with the jury at that time. As the court said in the order, this was conduct unknown to the state and other individuals. My office's position has always been that the conduct, while inappropriate and should never be condoned, was ultimately harmless as it related to prejudicing Alex Murdaugh's right to a fair trial.
It's Murdaugh. He says it's Murdaugh. Why can't anybody just say Murdaugh? Why do they insist on Murdaugh? Like, you're the attorney general. Just pronounce it properly. Look at Creighton Waters' face. If you're not looking at your screen, you're listening to the attorney general speak right now. Creighton Waters is just like, mother, I can't believe I'm going to have to do this again. He's got just a face on like he's just like, oh, bastard. Bastard.
The Supreme Court obviously disagreed in its conclusion. While we strongly disagree with the Supreme Court, we respect its decision because that's how the process is supposed to be played out. So now we must look to the future. What does this decision mean going forward for this office? First, Alex Murdaugh is currently serving a 27-year sentence for the financial crimes that he has admitted to in a guilty plea that we secured against him. And he has also waived his appeals for those financial charges. Additionally, he pled guilty to federal charges about 5 months after he pled to the state financial charges. He received a concurrent 40-year sentence in addition to the state's charges. So Alex Murdaugh will not be getting out of prison for several decades. Currently, our office is reviewing the Supreme Court.
Mr. Warders, blink if you need help. Blink if you need help, sir. You will not be getting out of prison for several decades. Don't worry. Don't worry.
Be getting out of prison for several decades. Currently, our office is reviewing the Supreme Court's order. We're meeting with members of our legal team and our staff. We're evaluating what our legal strategy will be going forward. As of right now, the state has 15 days to ask the state Supreme Court to reconsider its decision, and we have 90 days to appeal to the U.S. Supreme Court. However, it is currently my intention to seek a speedy retrial in the case against Alex Murdaugh. Obviously, I always say this with the court's current decision. We obviously recognize that all defendants have the presumption of innocence unless and until they are proven guilty in a court of law, and Mr. Murdaugh will enjoy that presumption at this time. Are there any questions?
Mr. Attorney General, your opponents in the governor's race are jumping on this, saying your office bungled the case. I know the court's decision pointed the finger at Becky Hill, but are you worried that this is going to affect your campaign for governor and will look poorly upon your records?
No, not at all.
Yes, so he's running for governor. And props to that reporter for saying, people think you bungled the case. What do you have to say about that?
Obviously, the court has been very clear. People who have never actually been a prosecutor, been in law enforcement, stepped foot in the court of law, held the hand of a victim as they got a jury sentence read, have ever gone through this process. They can make all the political haymakers they want out of this. But at the end of the day, people were murdered. People were murdered at the end of the day. And if people want to make this a political issue, that just shows their character or lack thereof. This office and the men and women who worked in this office at that time and who will be working on this case going forward are some of the finest prosecutors, finest investigators that I have ever met. Whether they're at SLED, whether they're in this office or other law enforcement agencies that we worked with, they did their jobs. The Supreme Court even said that in its order, that the state of South Carolina did its job right.
So he just nodded his head. Linda said, did they just have Waters propped up there? It's like Weekend at Bernie's. One of the best movies of all time. Weekend at Bernie's. He's propped up there like Bernie. But I think he will speak after the Attorney General is done with his and refuses to take any more questions.
Obviously, this court gave us some guidance going forward in the next trial regarding how they would like to see evidence handled or presented, rather. But they placed this squarely on the shoulders of the former Carleton County Clerk of Court. Anyone who says otherwise is purely playing politics with a very, very serious issue.
Would the trial be Wilson here or Walterboro, or do you know?
We would expect it would be in the same jurisdiction that it was originally tried.
Why? There were issues with the clerk of court in that court.
The clerk of court has been convicted of misconduct and is no longer the clerk of court.
So you're not.
Yeah. I heard Harpootlian say in an interview that I can't play for you because they'll strike me. But I heard him say yesterday, right after the decision came out, Harpootlian's like, I don't even think the way he made it, I don't think I'm going to even have to argue for a change of venue. This is not going to be tried in Carleton County. He's entitled to a jury made of the same demographic as Colleton County. And so there are certain counties, he said Colleton County has a 35% African-American population. And so it's got to be held in a similar county, but this will not be tried in Colleton County. That's what he says. So he's completely disagreeing with you, sir.
Expect any other possible issues in Colleton County?
Well, Colleton County is not the reason that the clerk of court did what she did. That was the clerk of court's decision.
Could she face any other charges as a result of this?
We're not going to comment on any other possible. Obviously, the case against the former Colleton County clerk of court was referred to another solicitor for review. That solicitor made criminal decisions regarding the totality of her conduct. She pled guilty to misconduct charges with conduct unrelated to this case. I'm not going to speculate on anything else at this time. Yes, sir.
Did this ruling come as a surprise, and what can you tell to the people of South Carolina who might be worried about the cost of a second trial?
Well, first off, our office has always maintained, and we've never disputed that the conduct Ms. Hill engaged in was inappropriate. We have always maintained that the conduct was harmless error. Obviously, if you, for those of you who watched the post-trial hearings, for those of you who saw everything unfold in real time, there were many witnesses who testified that this, I think 11 of the jurors testified in open court during that post-trial hearing that they did not believe that this affected their decision.
Doesn't matter. Doesn't matter. All it takes is one. All it takes is one. And the Supreme Court, I count them. How many did we find? 3? Harmless error? No, it was harmful. And how can you even with a straight face say that now after Becky Hill has been convicted and pled guilty to perjury? Sir. Like, fall on the sword. Be like, what she did was horrible. Absolutely horrible. We're sorry that it's costing the taxpayers more money, that we're going to have to try this again. What she did was unforgivable and egregious, like your Supreme Court said.
We believe that it was harmless error. And so obviously when the court came to a different conclusion, it was obviously disappointing to me personally. I know it was disappointing to Creighton. It was disappointing to other members of our team.
Blink Creighton.
And as far as the cost of the second trial, for those who might be concerned about the legal costs incurred going forward with this, considering he is behind bars for several decades.
Here's the thing. When people are murdered, okay, when victims are murdered, they have a right to have their case adjudicated in court, even though they're not currently here. Their family members who they left behind have a right. For those who want to see justice meted out, they have a right to that. So we're not going to let that be a factor in our decision to move forward. Seeking justice is the role of this office. Enforcing and defending the rule of law is the job of this office. It is the job of the men and women of this office, and that is what we have always held to.
Do you plan to prosecute the case any differently this time?
As I said a moment ago, Mr. Waters and I have been in consultation all day. He's been talking with members of our team here in the State Grand Jury Prosecution Division. We don't want to comment publicly on what our legal strategy would be moving forward. Obviously, there will be very little surprises to the general public as this case gets retried again. But obviously, we have a roadmap the Supreme Court has given us based on what they have put forward in their order. But again, I don't want to talk too much openly about what our legal strategy would be because we haven't gotten there yet.
Was there ever any consideration of possibly taking this case up to the Supreme Court? You said you had a window to possibly get that done.
We're still in that window for 3 more months. So obviously, it is something that we are contemplating all of our legal options, and we're exploring everything. This just happened today. So making a firm decision one way or the other on what we want to do on our right to appeal are things that we're going to be talking about in the hours and days to come. And we will be making those decisions. Regardless of that, is my current intention to seek a speedy retrial of this case.
I mean, these are legit questions. Why is he turning anybody else off about how he's treating the reporters as if they're idiots? While Goose backed his sled or her sled over the like button, you should too. Do you think this will affect his run for governor? Karen says this looks like a Carol Burnett episode with Tim Conway. It does. It does. That's crazy. I don't know, right? Vibes are off. Tara says there's something about him. He's not passing the vibe check. Vibes are off.
With the documentaries and the different podcasts that are already out, do you think that will taint anything in the case or the retrial?
I mean, look, you always are concerned about the exposure a high-profile case gets, and that is always something you're concerned about. But obviously, the process is designed and built to kind of cull that out. And obviously, I trust the process and the system to help us get back to a court of law where we can get this information back to a jury.
How quickly do you expect you could be back to trial with this?
My intention, and we've talked about this, it's aspirational, but we would like to try to get back before the end of the calendar year.
Aspirationally, they want to get back. Try this case before the end of 2026. He's being aspirational. I mean, somebody asked if it's going to be the same judge. No, Judge Newman retired, right? He is this is the current attorney general who is running for governor. Creighton Waters still has not moved much. It's sus. It's sus. Vibes are off. Okay. So if they were to appeal this, that would take much longer than Freeze game is so on point. Come on, hold on. Look at his face. It's like the big frown. I mean, the frown. Turn your frown upside down, sir. Turn your frown upside down.
You might not be attorney general at that point. You might not be attorney general at that point.
She's like, well, you might not be attorney general at that point. And he just told another reporter on the other side of the room to talk to the hand. Talk to the hand. Watch. I hate when people do that.
Year.
You might not be attorney general at that point.
Irrelevant. It doesn't matter who the attorney general is. The office of the attorney general will still be here. Would I like to be involved in this case like I was the first time? Absolutely. But like I said, the men and women, many of the men and women who were on that original trial team are still in this office. Some have obviously moved on to other opportunities, but most are still here. This office is still going to be here long after Alan Wilson leaves it. So the decision on whether or not to pursue this case.
He's talking about himself in the third person. George is getting upset. George is getting upset. He doesn't say I. He says as soon as, and then look again at his frown. That he looks like a frown emoji. He looks like the frowny emoji. The Office of Attorney General is going to be here long after Alan Wilson is gone. Anybody know the song Brian Wilson by the Bare Naked Ladies? Lying in bed? Lying in bed just like Brian Wilson did. Rework the lyrics for Alan Wilson and it fits. George is getting upset. Hold on. He looks like a Muppet. Like that is the biggest frown I've ever seen. There's so many more jokes we could make about Creighton Waters' appearance during this little presser, but I can't think of them all right now, but I know you guys can. Here we go. Right. And look at him now. He's like, out of here. Yes, I agree. I absolutely hate, Lucy says, when the person who did all the work stands in the background, it just feels disingenuous. Yes. Like, it's crazy. Right. How about Law Mama 4 says, can the attorney who did the lion's share of the work on this case speak now, Wilson? Ugh. He totally looks like the yup Muppet, said somebody.
Obviously moved on to other opportunities, but most are still here. This office is still going to be here long after Alan Wilson leaves it. So the decision on whether or not to pursue this case is not going to be built on who the next occupant of my office is. It's going to be built on should we seek justice or not, and we're going to seek justice. I'll take another question or two, then we have to run.
I guess, Attorney General, there's been calls for...
Okay, we have a sigh emoji, and if you listen really carefully, turn your volume up for a moment, you can hear Creighton Waters go, He's trying to breathe deeply because this guy just said, okay, we'll take another question. And then we're out of here. We got to go. We got to think. Stace, I got to go. Looking at the phone. I got to go. He's like, you're not even going to let me speak? I have so many things to say. I got to rewind it.
On should we seek is not going to be built on who the next occupant of my office is. It's going to be built on should we seek justice or not, and we're going to seek justice. I'll take another question or two, then we have to run.
I guess, Attorney General, there's been calls for
Hear it?
reform of the system. You yourself have called for judicial reform. Given that the finger's been pointed at the clerk, are there any reforms you think should happen for clerks within the judicial system?
Look, the system worked when it came to the former clerk of Colleton County. Obviously, after the fact, unknown to us, as the court said in its order, her conduct was obviously made known. That was handled by the system. Other conduct that she engaged in, which was discovered long after the trial concluded, that ultimately led to her conviction for misconduct in office, was handled by another solicitor's office that I signed them that case. And that was handled appropriately, and she was convicted in a court of law. So the system addressed that individual.
And I know you're not going to speak about your strategy, but do you think the evidence that they pointed out that you spent too much time on the financial woes of Murdaugh, do you think that's going to have an impact on your trial?
I mean, look, we have the benefit of hindsight now.
Sir, maybe you should let Mr. Creighton Waters answer that question. Because really, what did you have to do with the trial at all, if anything? Wild Goose did it, perfected the lyric lion and sled, just like Alex Wilson did. Well done. Creighton is questioning all of his life choices right about now. Sherilyn, all of them. But he won't let him answer anything.
We believed, and the court did say in its order that the evidence that we got in was permissible. They obviously provided us some guardrails to go back on remand to the original trial court where it will be tried. And they gave some guidelines and some guidance that we will obviously evaluate and use as a guide in presenting the next case. I'm happy, Creighton, if you want to take a moment, I'm happy to let you address that issue as well.
Yeah, I mean, absolutely. We, of course, were, aggressive about that evidence. But as you recall, we
I forgot to put the captions back on. Sorry.
Filed multiple pretrial briefs. We laid out our theory of the case. We put all that evidence on the table, and ultimately Judge Newman heard it all and agreed that it was permissible. But this is part of the process. The Supreme Court multiple times in the order said that this was viable evidence of motive, but ultimately gave us some guidance about the extent. That's how it works. You don't hit a home run if you're afraid to strike out. And so as a prosecutor, you have to deal with double jeopardy. We had a viable reason for putting in this evidence, and so we did so. Ultimately, the court, as the AG said, ruled on Becky Hill. And then they said, while we're at it, hey, this is permissible evidence, but let's put some guardrails in place. That's just part of the process. They also, though, multiple times in the order talked about I think they called superbly competent and professional presentation by both the state and the defense. So these things are not 2 + 2 = 4. And we did our job. We still believe that the case should have been affirmed, but we recognize the court's reversal, and now we're going to go do it again. That's the plan.
Mr. Waters, thinking back to January, in which arguments were brought before the state Supreme Court, was it a difficult or untenuous position to have to, in some ways, talk about Becky Hill and basically, in some ways, make sure that, to say it no other way, to kind of defend her in that hearing?
Well, again, whenever you try a case and you, as a prosecutor, like I mentioned, with double jeopardy, you have to, within your interpretation of the rules be aggressive. And so we were expecting that. The one thing you don't expect is to ultimately have to address these issues with the clerk. As we presented to the court, and as the AG just said, we thought that Justice Toll got it right, that ultimately there was no effect on this verdict after 6 weeks of trial and all the evidence that was presented. Supreme Court saw it differently, and that's their prerogative to do so. So certainly that was not an issue that we were hoping for and expecting. And unfortunately, that was the one where the Supreme Court hung its hat. But again, that's part of the process. You dust yourself off, you get back up, you take a fresh look at it, and then you go do your job. And that's what we plan to do.
I want to close by first off, just thanking the team in the Attorney General's office. Obviously, we're disappointed, but I could.
As he pushes him away from the podium, pushes Creighton away because he knows Creighton makes a better appearance than he does. And the camera person didn't even want to put him back in the frame, but begrudgingly did. Watch that again. Excellent work on behalf of the camera person. Watch him push him out of the way.
Just thanking the team in the Attorney General's office. Obviously, we're disappointed, but I couldn't be prouder of the job that Creighton and his team did. We lived through 6 long weeks 3 years ago, and we believe we did a good job for the people of South Carolina. We believe we represented the criminal justice system very well. A lot of people didn't think we could get a conviction, and we got it. Unfortunately, someone, unbeknownst to us, engaged in conduct that the Supreme Court believed prejudiced a defendant's right to a fair trial, and Supreme Court made the decision. While we don't agree with that decision, we respect that decision, and we're going to comply with that decision, and we're going to follow the rules given to us by the court, and we're going to move forward. Again, we will keep you all up to date as much as we possibly can on all the developments that come out. Obviously, we have a lot of work to do. We have to reevaluate. We have to review. We have to meet with people and make decisions in the coming weeks. Again, our hope is to get this case retried by the end of the year, but obviously, time will tell if we're able to do that. But that is our intention at this time. I want to thank all of you for giving us the opportunity. I'm sorry it was late in the day, but we had to absorb everything. We had to meet with a number of people, and we wanted to be able to give you this information as quickly as we possibly could. So thank you so much. I hope you have a wonderful day.
Right. That is State Attorney General Alan Wilson, along with Chief Prosecutor Creighton Waters.
Creighton grabbed his papers and ran off. He's like, I'm out of here. I'm done here. I'm done. You. We need proof of life on Waters. He did. He said something. He said something. Olivia just got here. Hi, Olivia. Are they trying to say the Supreme Court didn't find any error with the prejudicial financial crimes info coming in? No. Did you read the opinion? They said it. Some of it was okay for a proof of motive, but that when they started getting into some sort of inflammatory stuff about that Tony Satterfield testified that his brother was, I forget the word that he used. Hold on a second. His brother was, I don't want to misquote it. Where is it? It's a long opinion. If you haven't read it, go back and read it. Some of it was too inflammatory. Like Tony Satterfield's testimony about his brother being a vulnerable adult and he's not able to function like a normal human, and that he has a disability, and some things like that might have been more prejudicial than probative, and they gave them certain guidelines for the retrial, but they're not saying not any of it, that none of it can come in, They're saying stuff that's not more prejudicial than probative. That a basic understanding of it for the jury could lead them toward motive. Yeah. Were they gaslighting? Oh, you mean were they gaslighting during the presser? Olivia says, unpopular opinion, he deserved a new trial even without Becky Hill's misconduct. The prejudicial financial info never should have come in a trial. Some of it did go to motive. So would they have overturned if Becky Hill didn't do what she did? I don't know. It will be a new judge this time, Tammy. YouTube turns. Melanie, did you hear the song called Cancun with Melanie? I did not. What is that? Thank you for your 5. Undercover. Angel says Alan Wilson was in the courtroom with the prosecution the vast majority of the trial. But was he sitting at defense table and assisting in the prosecution, or was he sitting in the courtroom like Mark Diller sat in the courtroom for the entire Karen Reed trial number 2? Oh, and even some eagle eyes found Mark Diller in the courtroom during some pretrial proceedings of Karen Reed. Did he assist in the prosecution, or was he just sort of overseeing and being present in the courtroom? Nana Bear said, I watched the trial. I knew nothing. The DA did a great job. Will you guys watch the retrial? Should we do a poll? Let's do a poll. Let's put up a poll. I mean, if they plan to try it before the end of this year, depending on scheduling and, whether or not they get a judge in a different county, whether or not it's tried in the same county and they bust a jury in from another county, these are all things that need to be determined, but sounds like they're ready to go. And so is Harpootlian. Harpootlian said he's ready to go too. And he's eager. And he said Alec was very surprised. He never thought he was going to get a new trial, so he was pretty surprised. He's a couple of hours away from where they are, where he's housed, apparently. And I would like to know, I'm going to do a little poll here. Will you watch the retrial? And the answers are going to be hell yes or hell no. There you go. Let's try and get a good sampling on the poll. There's I don't know, over 2,600 people here. Let's see how many. Let's see. Oh, you'll only watch it here. You guys are so loyal. I love you guys so much. Look, only with me. Only with me. Poot made me cringe, says Julie. Yeah, and if you're here, smash the like button too. That helps. And then I'm going to talk to you a little bit about our next trial, which is starting on Monday in Suffolk Superior Court, Massachusetts. They're picking a jury, and the jurors that have already been selected have been told to come back on Monday morning at 9. And the judge has allowed the media to come in and film it and live stream it. So we're going to be watching it on Monday. Oh, Olivia even says only with Melanie. I love it. Little Cupcakes is only with me. That's awesome. Yeah, I'll be here. I'll be here for it. How many days did we spend on the Karen Reed trial number 1 and 2? At least 30 days of trial per trial, at least. Oh, you guys are awesome. Only with me. I love you so much. Thanks, Berkey, for becoming a new member. I love it. Keep voting. Okay. In the meantime, any more thoughts, questions, comments, concerns before we pivot on over to talk about the new trial that we're going to cover on Monday? Aurora says, I'm going to watch to see if Poot has taken gun safety. 22 months. You're an OG girl. Andrea said, I never watched the first trial. I thought he was so guilty, so I didn't bother with it. I wonder if the evidence comes in differently. Harpootlian said in the interview that I watched this morning, he said there was absolutely zero forensic evidence tying Alex Murdaugh to the crime. For me, it was the Snapchat video. I'm like, this guy was effed by Snapchat. He lied about being at the kennels, and then they found that Snapchat video that Paw took, and it showed that Alec was there when he said he wasn't there. So for me, that's what sunk him in my mind. Yeah, they never found the firearms. Right. And Dick Harpootlian is also saying that they've been getting lots of tips since the trial ended. And the girl pressed him a little bit, who was interviewing him. And he said, well, I can't really talk about it, but, we've gotten some information about where the firearms may be. and things like that. Official Row Queen says that Snapchat video didn't prove anything. To me, it did, because he lied and said he wasn't down there, and then he was in the video. So for me, it did. Why do you say that you don't think it proved anything? Didn't prove that he murdered them, but made him look like a liar, in which case the jury could have thought, why did he lie about that? It was a stupid thing to lie about. Did you buy the argument? Let me ask you this, Official Row Queen. Did you buy the argument that because he was addicted to opioids, that's why he lied about that? Did you buy the argument that because, he was an opioid addict, that he couldn't remember things, or his memory might be faulty, or that he would lie because addicts lie? Let me know what you thought. Green-eyed Southern Girl says, I don't believe the opioid stuff for a minute. Esme said, I agree, but the lack of forensic evidence, including no blood in the car, is off. It wouldn't surprise me if he had someone else do it. Also, Harpootlian said this morning, as we talk, I'm remembering more things that he said. There was blood spatter on Alex's shirt that was tested, and apparently the test results were that it was not human blood. So I don't think that ever came in. And I don't remember if he said that he got those results after the trial was over, or if it was just something that was never introduced, or that they were dumped a lot of stuff right on the eve of trial. Dave Matthews' neighbor says, why didn't they test his hands for gun residue that night? Olivia says the state's iPhone expert, in air quotes, was absurd and shouldn't come in again. Green-eyed Southern Girl said, yeah, and the only gunshot residue was in that raincoat. Right. Ann Smith says he took more medicine in a day than I thought was humanly possible. I know. Same. Lucy says a loving father would not lie about being at the kennels, in my opinion. If you're truly seeking justice, especially your child having his head effectively removed, would make him want to tell the truth. Ellen says Snapchat video and phone and Blanca and the mother's nurse did it for me. Oh, right. Wasn't the mother's nurse asked by Alec to lie about the time he was there and how much time he spent at his mother's? Because that was part of his alibi. Alien Lee said, it's weird to me that he invited Paul and Maggie to Moselle, but not Buster. Rainey May said, phone in-car data and Snapchat video did it for her. Creating Through Chaos says Sled dropped the ball on this. Esme said there was drama about blood spatter, but I believe the expert wasn't called. Yeah. Melissa said, Olivia, he's a phone expert. He threw his phone a few times at home. It's kind of like Ian Whiffam putting his phone in the freezer to run his experiments, right? Or driving over hills in his car and waving his phone around to see if it would register steps. I know. People say, why does everything go back to Karen Reed? I don't know. Because it does. Just because it does. Miss Lou said, I didn't buy anything regarding his opioid addiction. And two moms. Yeah, so Poot and his sidekick are going to do a press conference on Monday, he said. So we'll have that to look forward to on Monday. Everyone's talking about the phone expert throwing his phone around the office. Official Rogue ENT says they focused too much on financial because they couldn't prove murder. Allie in Texas, he was deep in the good old boys network down there. Lee Gilly, the guy charged with capital murder of his pregnant wife in Texas and fled to Italy, is tied to them too. It is so crazy. Cupcake Diaries 87 said, didn't he take a shower before calling 911, changed his clothes? Leah says, it's my opinion, Alex Murdaugh knows who did it and maybe witnessed it and it was done because of him, but not him that actually did it. That's an interesting theory. Right. Green Eyed Southern Girl says, and he told Blanca, I was wearing that Vinnie Vines shirt, remember? And he didn't. I don't know. Anybody calling Vineyard Vines Vinnie Vines, in my opinion, is guilty of something. Calling Vineyard Vines Vinnie Vines is a crime in and of itself. I don't think he Googled how long to die in cold. Did he make any Google searches though? Was that part of the trial? Crafty K says opioid addiction was a distraction. Financial crimes was motive. Snapchat was the nail in the coffin. Lady Laura says, depending on SLED is like depending on the GBI. You shouldn't. Fire Walk with Me says, SLED agent David Owens admitted to lying to the grand jury. Oh. And Olivia says, because Karen Reed's trials embodies so many examples of corruption and what not to do. Green-eyed Southern Girl. Miss Shelley was an important witness and she was so scared on the stand. They're good people. Made me want to cry. The glares. Stroked beard. Well done on the username, sis. I didn't watch the first trial, so I'll be really interested in this one. Elizabeth said he changed his clothes. The kennel hose was left uncurled. Paul's phone stopped responding minutes after the Snapchat video. Okay, so drama must remain on the stage. All in caps is yelling at me and says the way they say his name, Murdaugh, is the way it's pronounced. Well, I mean, if you want, I could pull up Alex Murdaugh's testimony, but I believe that when he says state your name for the record, he says my name is Alex Murdaugh. I don't want to fight with you about it. I mean, I could. You guys tell me. Melinda says, I lived in the Low Country for 20 plus years, and yes, it's a good old boy system, and they genuinely talk like that, Bo. I'll allow it. Sai says, maybe unpopular opinion, but I still to this day do not think Alex Murdaugh was the trigger man. KK Billingsley said, I've always felt it could have been someone related to the girl who died in the boat accident. Rest in peace, Mallory Beach. Everything is 6 degrees from Karen Reed. Noni, you know that. Excellent point. Leah says, the way the financial crimes came in during Corey Richard's case versus Alex Murdaugh's highlighted for me the difference in prejudicial versus probative. Meme on Nancy says, Alex Murdaugh says, he says it like Murdaugh. I mean, I'm going to go by the guy whose name it is to decide how his pronunciation is. That's just me. Law Mom says it's pronounced Alex Murdaugh. Alex. Oh my God, you gotta watch the Hulu miniseries because Patricia Arquette as Maggie is fantastic. Thanks for rolling in the steeps. Be a deuce. Appreciate you. Ski Utah. I love Utah ski. I love skiing in Utah. Park City is my jam. Alex definitely had help. Karen says, I watched every bit of coverage pre-trial, watched every second of the actual trial, and hell yes, we'll be watching a retrial. Sickly Denise, I'm so sorry if you're really sickly. Says, I do believe, though, if he was involved, he wasn't the one who pulled the trigger. People agree with me. Doc. The pronunciation. Lucy said, oh, yeah, remember the steps he took in that 10 minutes that showed him possibly running around the house? Calamity Jane says, the first trial, I was absolutely glued to it, and I will be this time as well. Southern Girl says it's really sad because Paul was joking with his mom and he sounded so happy. Who doesn't love an Arquette sister, says Goth Boy UK. What happened to Rosanna? She doesn't really do so much anymore, right? You know they wrote that song for Rosanna Arquette, right? The Rosanna song. Who sung that? Was that Toto? Oh man, that's old. I'm dating myself. Okay, I'm going to now. Let's talk about the new case that we're going to start covering come Monday, because come Monday, it'll be all right. I think it's song lyrics. Okay. The trial that is starting Monday, they are currently picking a jury in Suffolk Superior Court. Let's see, we have only 600 votes. Come on, you guys, get in there. Just hit yes or no. Will you watch the retrial? So far, 91% of you say yes, but it's only 600 votes, so it's not really a very good sampling. All right, let me pull up my reference documents and tell you what's happening come Monday in Suffolk Superior Court in Massachusetts. This is the case that nobody wants you to know about because there hasn't been a lot of coverage on it and nobody's talking about it. And the defendant happens to be the brother of the current Attorney General of Massachusetts, Andrea Campbell. It's her brother on trial. His name is Alvin Campbell Jr. He's now 45 years old. He's charged with sexually assaulting, raping 9 women between 2017 and 2019. The allegations are that Alvin Campbell Jr. masqueraded as an Uber driver, and in one case, a bar employee, and he targeted women at venues in downtown Boston who were too intoxicated to consent to his sex acts or to resist his assaults. He's the older brother of Massachusetts Attorney General Andrea Campbell, and he's going to trial starting Monday on a slew of rape, kidnapping, and indecent assault and battery charges, among other counts. He also filmed them. He filmed these encounters. They found footage on his phone. Right. And he just didn't commit any crimes after 2019. And it also took them a while to arrest him. Hold on one second. But before we even get to this guy, let's talk about do you know the lore of the Campbell brothers? Of the father and grandfather of Andrea Campbell? They were the Campbell brothers were an American crime duo active in Boston for several decades during the mid-20th century, consisting of Arnold S. Campbell and Alvin R. Campbell Sr. This is Alvin R. Campbell Jr., who's on trial. The Campbell brothers were regarded to have associations with the Winter Hill Gang. Their criminal activities primarily centered in the Roxbury neighborhood of Boston. This is Wikipedia I'm reading from. The Campbell brothers were plaintiffs in the 1963 United States Supreme Court case, Campbell versus the U.S., which related to their criminal trial for a 1957 bank robbery. The ruling granted them and a co-defendant a retrial in which the brothers were again convicted but received a more lenient sentence. In the late 1960s, the brothers were tried along with their acquaintance, Dennis Chandler, for the November 1968 triple homicide of Guido St. Laurent, Carnell Eaton, and Harold King, who were shot in an attack on the Roxbury headquarters office of the community nonprofit NEGRO. All 3 were acquitted, found not guilty. A key witness to the attack was killed before the trial. Johnny Martorano, a Winter Hill Gang hitman, confessed decades later to murdering the witnesses to prevent him from testifying against the brothers. In the early 1980s, authorities claimed that Alvin Campbell was the leading Black organized crime figure in New England. you can go to Wikipedia and just look up Campbell Brothers criminal duo. And those two were the father and grandfather of current Attorney General of Massachusetts, Andrea Campbell. You know why? You know, because you just can't make it up. You just can't make it up. Very few articles are even available on this. If you even look into like the Twitter sphere and just look at Alvin Campbell Jr., you're not going to find much on it either because nobody's talking about it. Let's look at the Boston Herald because they did a piece on it the other day when jury selection began. So the chosen jurors, I think they're looking for 16. I think as of yesterday, they had 12. They were going back to continue picking today, but all of the selected jurors have been told to return Monday, and there's going to be a camera there. I'm going to cover it. I'll watch it alone if you guys don't want to watch it, but here it is. Trial of accused serial rapist Alvin Campbell begins. Look at him smiling in court. He's got a big smile on his face. And that was from 2024 when he came into court one day. Big smiles. This article is from May 11th, which was just a couple days ago. Would have been Monday, right? So this is when they started picking. Jury selection for the trial of Alvin Campbell Jr., who stands accused of posing as a fake rideshare driver and graping 9 women from 2017 to 2019, began in Suffolk Superior Court on Monday. Campbell, age 45, the elder brother of Massachusetts Attorney General Andrea Campbell, was arrested in January of 2020 and faces charges of aggravated rape, assault and battery, indecent assault, photographing an unsuspecting nude person, and more related to alleged assaults of 9 women. The defendant lived in Rhode Island, but allegedly committed the crimes in Boston between 2017 and 2019. Prosecutors say Campbell posed as a rideshare driver and sometimes a bar bouncer to prey on intoxicated women and film the assaults. The defendant also faces separate charges related to allegedly attacking a correctional officer at Suffolk County Jail and assaulting 2 inmates at Hampshire County Jail and House of Correction. AG Andrea Campbell released a statement ahead of the start of her brother's trial Monday. Quote, "As my brother's trial begins, I am praying for the survivors and all those affected." The Attorney General posted on Blue Sky. Is she the only person posting on Blue Sky? Is Blue Sky even a thing anymore? Didn't that come in as an attempt to like to be like a friendlier Twitter? Do people actually use it? I have so many questions. Hang, please. Those pop-ups are going to make me nuts. Quote, "It takes extraordinary courage to come forward, and they deserve dignity and respect. This is an incredibly difficult situation for everyone involved, and I carry that weight with me, including in my prayers for my brother. The case is now before the court, and I respect the judicial process as it moves forward." Suffolk Superior Court Judge Mary Ames presided over a long day of jury selection as the trial kicked off in Suffolk Superior Court on Monday. Many potential jurors came before the court throughout the day, being asked about being shown graphic images and videos of acts, histories of assault, feelings towards police, racial bias, and more. Some potential jurors were openly emotional or in tears about the subject of the trial as Ames questioned them on Monday, while others stated they would not be able to remain impartial on the subject of SA. I mean, some jurors were in tears, even just hearing about this. In January of 2020, Campbell was arrested in relation to accusations that he impersonated a rideshare driver to get a woman in his car near North Station that December. So December 2019. Police found Campbell while he was talking on his phone and secured a search warrant to go through the device and cloud-based data storage. Prosecutors say investigators found recorded videos and images showing 8 more women being essayed by the defendant on his phone and tracked down the alleged victims shown. Wow. Well, that's good police work, right? The evidence shows what prosecutors have called an alleged pattern of Campbell misrepresenting himself and seeking blackout drunk women to prey upon. They found it on his phone and they tracked the women down. And again, all things lead back to Karen Reed's case. We know from what we've learned about Proctor's phone extraction that they found at least 12 or 13 years of data, including intimate body parts and pictures of victims. Both, maybe it's both men and women. I assumed women, but maybe it's both men and women. Nudes. And my question is, are they going to track those women down and men and let them know that their pictures have been passed around by Proctor and his cronies? Don't you think they should? Don't you think they have the right to know that? And don't you think that if they did, they'd have a really good civil case? Do they not want to open themselves up to litigation, so they're not even going to try and find out who these women are? Because I think this was Boston PD, and they did. While some alleged victims have vague memories of assaults and others have none at all, prosecutors stated in court filings all the rapes or assaults were documented on the defendant's phone. The prosecution charged Campbell as a habitual offender. Campbell has a history of prior convictions, including armed assault with intent to rob and assault and battery in 2000, being a felon in possession of a firearm in 2006, and carrying a firearm without a license in 2014. The defendant's grape trial was pushed back several times as he went through a series of defense lawyers, now taking place over 6 years after his initial arrest. And that was published Monday in, what did I say? The Herald? But wait, because there's more. My deep dive. In my deep dive, there's not a lot of information about this case. This is a 2024 article on a website called WBUR. Does anybody know what that is? What is WBUR? Is it a legitimate source? Is it like Boston University Radio or something? If anybody really knows the real answer, tell me. This is an article that I found in WBUR on their website. Boston police failed to arrest serial rapists for years despite DNA evidence. What? DNA evidence, you say? Allie says the media has covered it up. It's outrageous. Somebody filed a media order, and the judge is allowing a camera in and a still camera. I'm hoping they're going to live stream it and not just tape clips to put. It's NPR in Boston. Okay, thank you. Just clips for them to put on the news. It's a very credible source. Thank you. All right, this is an article from April 22nd of 2024. Maybe triggering for some, so I'm going to just trigger warn you. I'll try and use the fake words. It started off like countless other Uber rides in downtown Boston. A group of friends piled into a car after hanging out at a bar. Then they started arguing. Most of the friends got out at their hotel, and the man offered to drive the remaining rider around to, quote, collect herself. You don't think? Oh, you must. I think fork to spoon, you're behind, and you're probably talking about Alex Murdaugh, because this guy has video evidence that he did it because he took video of all the victims. But when the woman asked the driver to drop her back off at the hotel, he refused. Instead, he took her to his apartment in Dorchester, that Saturday in July of 2016, and essayed her, police alleged in court records. A DNA test identified the suspect as Alvin Campbell Jr., a burly 43-year-old with a long criminal history and a prominent relative. Campbell is the brother of Andrea Campbell, then a Boston city councilor, and now the state's attorney general. Thanks, Team Brittany. I'm going to star that for later, or just put it up now so everyone can read it. Despite the DNA evidence, Alvin Campbell was never arrested or charged in connection with the encounter, and police never alerted the public. Oh, well, that's interesting. How many other women were raped because of their failures? Over the next 2 years, a WBUR investigation found 3 more women shared similar stories with police about a man who assaulted them after offering them rides at Boston bars. In each case, DNA and other evidence pointed to Alvin Campbell, according to an application for a search warrant obtained by WBUR. And each time, authorities decided not to detain him or seek criminal charges. Oh, Olivia, I knew you would love this one. And this is great advice from Team Brittany. Ladies, never fail to use the buddy system when out with friends. Do not leave your friends alone, please, for the love of God and the traveling Mary. Olivia didn't know about this? Oh my God, I'm turning you on to something you didn't even know. Here we go. Boston police finally arrested Campbell in early 2020 after a 5th woman reported that she was raped. At that point, investigators made a horrifying discovery. They found evidence on his phone indicating he had essayed at least 10 additional women since the first incident in 2016. Another cover-up. Go figure. Here he is with a mask on, handcuffed at a court appearance at a 2023 hearing. Shy Charles didn't do his hair. If you know, you know. You guys are telling me that it is Boston's NPR. Thank you. Experts say the case is a striking example of how police and prosecutors often fail to take action when victims report essays, potentially allowing serial rapists to remain at large. A study sponsored by the research arm of the U.S. Department of Justice found that fewer than 1 in 5 rapes reported to police leads to an arrest. Even fewer result in convictions. This is the nationwide problem, said UMass Lowell criminologist Melisa Morabito, who co-authored the study. The whole way that essay is treated within the criminal justice system is in need of reform. This is a 2024 article. Morabito and other experts point to a long list of potential reasons. Sometimes victims don't want to testify because of concerns about the public court processes. Sometimes victims don't want to testify because of concerns about the public court process or retaliation. Investigators sometimes fail to test rape kits or follow up on other leads. Law enforcement agencies don't always share information, and the cases can be difficult to win in court because it's often the victim's word against the accused. Just a side note, Mariska Hargitay is started, I think, a nonprofit to get rid of the backlog in testing grape kits. We have to say grape on YouTube. I know it's stupid, but we have to. Nurse Dana, for those of you who watched The Pit with me, Nurse Dana gave some detectives a lot of shit one day when they came into the ER for other reasons because the grape kits had been sitting in the refrigerator for too long and nobody ever picked them up. Well, please. And it's degrading and humiliating to have to go through providing a grape kit in the emergency room. That was a whole episode too. Hold on. Back to the article. Quincy, for instance, recorded 6 grape cases involving unknown assailants from 2019 to 2021, the department said in response to a public records request. But the city said it never alerted the public and declined to provide details or share the police reports, citing the privacy law that says essay reports must be kept confidential. Quincy Police Lieutenant Terrence McDonald said the department has no indication the 6 assaults were related or committed by the same person. He didn't respond to questions about whether the city has received additional unsolved grape reports in the past 2 years. Boston and Medfield police also cited the same law to withhold records about the essays involving Campbell from WBUR, making it harder to determine exactly why authorities failed to act sooner. Even some information that is supposed to be publicly available is hard to find. For instance, some of the early assaults are only detailed in a successful request to obtain video and other records from Campbell's phone after his arrest in 2020. But clerks at the Boston Municipal Court Central Division said they were unable to locate the application for a search warrant despite repeated requests by WBUR over several months. WBUR eventually obtained the document from the Suffolk County District Attorney's Office. Next paragraph. The government's case against Alvin Campbell. Are you outraged yet? Scott McGinnis, who is always boots on the ground, says Massachusetts Attorney General Andrea Campbell has almost nothing to ever say. At least her boss, Massachusetts Governor Maura Healey, takes to the mainstream media propaganda microphones here and there. Right. Imagine the women that don't know this case is going to trial, but encountered this alleged defendant in the past. Thank you, Aunt BB. Linda says, here we go again, covering up here we go again. Covering crap up. Just cover it up. No one will know about it. This kind of stuff is the reason I don't go anywhere but my doctors and back home. Goth Boy says SVU has covered the backlog a few times. It's insane. I know it's not real life, but it's heavily influenced by reality. It is my favorite show. It's my I know it sounds weird, but it's my comfort show. You know, everyone has a comfort show. Like when you go back and watch like all the reruns. There are channels here where it's on all day long and all night long, and SVU is mine. Especially the earlier seasons with Stabler and Benson. For my kids, I think it's Grey's Anatomy. They have watched every season like 100 times. Venus Blue says Mariska got her grape kit backlog initiative in all 50 states. Yes, thank you, Mitchell. Fun fact, Mariska Hargitay is Jane Mansfield's daughter. Yes, she did a documentary about it. If you haven't watched it, check it out. Allie pointing out that those exams are so violating. Here's the government's case against Alvin Campbell, according to this 2024 article in WBUR. Campbell grew up in Roxbury and graduated from a vocational high school there. According to interviews and other public records, Campbell spent much of his adult life cycling in and out of state and federal prison for physical assaults and gun convictions. He is now awaiting trial at the Nashua Street Jail for the grapes of 8 women and attempted grape of another, making this one of the state's largest cases of serial sexual violence in recent memory. Campbell has pleaded not guilty, claiming the encounters were consensual. He has also been linked through DNA to 2 other essays where he has not been charged. In court, prosecutors and police allege Campbell preyed on intoxicated women at downtown Boston bars for at least 3 years, often posing as a ride-hailing driver. The first case mentioned in court records occurred when Campbell was driving for Uber and allegedly took a rider to his home and raped her in July of 2016. Boston police declined to say why they didn't arrest Campbell at the time, despite DNA evidence linking him to the crime. A spokesman for the Suffolk County District Attorney's Office said they couldn't pursue charges because the victim declined to testify. Uber removed Campbell from its platform 2 days after the alleged assault. Oh, they knew. But police found his black SUV adorned with Uber stickers more than 3 years later. And prosecutors say he continued to pick up women in the guise of an Uber driver. Stop. Just stop. When Uber fires people, how do they make sure that they take their stickers off their cars? It's a problem. Oh, motion to chat says Melanie is my comfort show. I love that for us. Thank you, Mastad, because you are amazing. Campbell, who's 6'3", also allegedly posed as a bouncer in the second case, reported to police. Two women who lived together in Boston told police that Campbell started talking to them and claimed to work at the Harp. The Harp. Has anybody been to the Harp? Hang on one second. Oh, Brittany, I think I would go with I would go with the full on Block Island for that guy. I'll take care of it. Block Island is so lovely this time of year. Anybody been to the Harp? Two women who lived together in Boston told police that Campbell started talking to them and claimed to work at the Harp, a popular sports bar near TD Garden, where they were hanging out one night in 2017. When the women had trouble ordering a ride, they said Campbell offered to drive them home. Don't do it. One roommate woke up in her apartment later that night to find Campbell naked on top of her. She told police she pushed him out of her room and locked the door. The other roommate recalled then waking up to Campbell. All right, earmuffs for the children. Penetrating her, according to the search warrant application. She told police her body felt like Jell-O, and just like the first case in 2016, DNA evidence pointed to Campbell. This is 2017. This time, both victims agreed to testify before a grand jury, but prosecutors, wait for it, prosecutors withdrew the case before jurors could decide whether to issue an indictment. I'm sorry, what? I'm sorry, what? Privately, the prosecutors said they doubted they could prove that Campbell raped the second roommate while she was sleeping because the women were drunk and had incomplete memories of what happened. Quote, even by her own account, she's not sure whether she actually said no, prosecutors wrote in an internal memo, which is quoted in a motion filed by Campbell's lawyers. It would be nearly impossible to prove lack of consent due to incapacitation because she has some memory of what happened. You can't make this up. You can't. That's why we're in the land of the lost, the upside down, inside out Narnia of the Massachusetts injustice system. How about you let the jury decide? They didn't even let the grand jury decide whether or not to indict this guy. Are you flipping kidding me? Where's Chaka? Because we're in the land of the lost. That argument appalled some experts who study SA. If you're too incapacitated to give consent, then you cannot give consent, said Morabito, the UMass Lowell criminologist. She said prosecutors owe it to victims to bring charges even when cases are complicated. Quote, just because these cases are hard to prove is not a reason to not go forward, Morabito added. If they're brave enough to come forward and report the crime and go through with the SA kit, which we know is incredibly invasive, we owe them that much to take the case further. Thank you, Melisa Morabito, for standing up for women's or SA victims' rights in general. Meanwhile, more victims surfaced. In 2018, a fourth woman told police a man drove her home from Boston's Howl at the Moon, a bar known for its dueling grand pianos and tropical cocktails. When she arrived home to Medford, she found she was missing her underwear and thought she had been SA'd. She told police she was heavily intoxicated. Medford police compared DNA from the investigation against a national law enforcement database. Again, it matched with Campbell. But once again, authorities decided not to make an arrest or file charges. Period. Both Medford police and the Middlesex District Attorney's Office declined to explain why. Here's a picture. I'll at the moon. A fifth victim came forward in December of 2019. The woman told police Campbell picked her up outside the Harp, the same bar where he'd allegedly picked up the two roommates 2 years earlier. She said she was drunk and mistook Campbell's SUV for an Uber. She woke up the next day at Campbell's apartment in Cumberland, Rhode Island, with the JJ pain and a cut on her breast. Like the other cases, DNA from a grape kit matched Campbell's information. Yet, once again, police seemed reluctant to take action. The woman said she tried to report the essay to front desk staff at the Boston Police Headquarters, but they were not helpful, according to text messages summarized by Campbell's lawyers in a discovery motion. The same document states that an officer later told her she had to make her allegations look like an abduction for the report to be taken seriously. Boston police did not respond to a request for comment. Yeah, they created more victims by not investigating. Thanks, weird girl. Melisa says, imagine how many haven't come forward. Well, you wouldn't even know about this story. How many of you live in Massachusetts and didn't even know about this and still don't know, even though the trial is starting on Monday and they are actively continuing to pick a jury today in Suffolk Superior? Here's a text message thread. Oh my God. And it looks like maybe this is this victim's text message. It says, I was drunk. I don't remember a thing from that night, but I have a voice recording of myself in your car, and there's no effing way you didn't know I was drunk that night. I wonder if she's texting with the perp. You picked me up with pee down my legs. You knew I was drunk just by my voice. You knew I was drunk, and I'm not blaming anyone. I'm grown, but you're still a grapist in my eyes. Disgusting. That's her text message. This is an illustration of text sent by one of Alvin Campbell's accusers to his cell phone as detailed in a search warrant affidavit. Campbell denied he raped her in text responses, the affidavit states. Regardless, Boston police finally arrested Campbell a month after the incident. Investigators searched the phone and found video of Campbell assaulting the victim in his SUV while she was unconscious. I have no words. Police also discovered a text message from another woman accusing Campbell of rape after he offered her a ride outside TD Garden. Hope, Iowa. Hope Loves Chicken says, what? Who does he know? Well, funny that you should ask. His sister is the current Attorney General of the state of Massachusetts, Andrea Campbell. His father and stepfather were well-known organized crime figures in Massachusetts. Maybe she had nothing to do with it, because now she's sending her thoughts and prayers out to the victims. I was drunk, she texted Campbell in 2019. I could barely speak straight, and you decided it was okay to F me. Police soon discovered even more victims. A broader search of Campbell's phone unearthed photos and videos from at least a half a dozen additional assaults, according to an affidavit attached to the 2020 search warrant. They also found images of two other incidents police were already familiar with, but had yet to bring charges. One at the Harp in 2017, and the one involving the Medford woman in 2018. Here are the accusations against Alvin Campbell. Look, they even WBUR even did a little graph for us. Let's look at it together, shall we? I need a sandwich. One of the best usernames of all time says, Andrea Campbell is shady as all hell. Deanne says, I wonder if John O'Keefe worked on any of those when he worked there. That's right. He was with Boston PD sex crimes, right? Olivia. Paging Olivia. Thank you, Mastad. I'm not going to do them today, but we will do a whole other show on the documents if you guys are interested in following this trial. So no rush. We love a good timeline, don't we? I just got chills when you said that. Mastad said O'Keefe was with the sex offender notification unit, not sex crimes. But he still worked for Boston PD, right? I don't know if there's a connection. I have no idea. But it was an interesting point. I Love Dogs 1970 says there's a reason why Boston PD or state police did not look into the death of Officer John O'Keefe. These are state charges, Courtney. These are state charges. Connor McManus sending us into another rabbit hole says, look into Andrea's twin brother, Andre. KBD says there has to be more victims, and I pray that they come forward. All right, let's look at the timeline here. The key is blue, alleged SA, yellow, alleged non-SA, and green, charges. Okay. Just going to have to scooch from side to side. Let me close some of these tabs because it is getting really drafty in here. Oh, hang on. I think I just closed that tab without. I got to check the results of the poll. I could take the poll down now, right? Okay, hang on. Get your votes in now if you haven't voted on the poll. The poll is, will you watch the retrial? That was of Alex Murdaugh. There's over 1,000 votes. 90% of you say hell yes. 10% say hell no. Last minute votes in 3, 2, 1. Going. All right, keep going. We're over 1,100. And 5, 4, 3, 2, 1. All right. 90% of you said hell yes. Only 10% of you said hell no. So when Alex Murdaugh is retried, of course, we're going to cover it. I'll cover it anyway. Oop. All right. Let's look at the timeline. July 2016. Campbell allegedly essays a woman he gave an Uber ride to in Dorchester after dropping off her friends. December of 2016, a chauffeur in Boston files a harassment order against Campbell, alleging he had to seek medical treatment after Campbell attacked him outside South Station. February 2017, Campbell allegedly essays 2 roommates after picking them up in a vehicle outside the Harp, a bar in Boston's West End. He's later charged with multiple counts of assault with intent to grape and with graping one of the women. And then in April 2017, Campbell allegedly essays a 4th woman outside the TD Garden. May 2017, Campbell allegedly essays a 5th woman in Framingham after picking her up in a vehicle at a bar in downtown Boston. Fall of 2017, the 2 roommates testified before a grand jury about what happened in February. Afterward, prosecutors withdraw the indictment. Wait, I'm confused. Did they indict and then they withdrew the indictment, or they didn't even let them indict? Because that's conflicting in both parts of this story. Court records show they doubted they could win at trial because the woman alleging Campbell raped her had been intoxicated and was not sure whether she actually said no. Can I point out that if you're intoxicated, you cannot consent? I mean, is that a thing in Massachusetts or not? Chat's frozen. December 2017, Campbell allegedly essays a sixth woman in his SUV. February 2018, Campbell allegedly essays a seventh woman he drove from the bar Howl at the Moon in Boston to her home in Medford. June of 2018, Campbell allegedly essays an eighth woman in his SUV. May of 2019, Campbell is arraigned on a charge of assault and battery for allegedly attacking a woman leaving the Tunnel nightclub in downtown Boston. September 2019, Campbell allegedly essays a ninth woman after driving her to her hotel. November 2019, Campbell allegedly essays a 10th woman after driving her to his apartment in Rhode Island. December 2019, Campbell allegedly essays an 11th woman in his vehicle and in Rhode Island after giving her a ride from the Harp in Boston. Anybody, if you've ever taken an Uber from the Harp and recognize this man as possibly being your Uber driver and you have no recollection of that night, or something did happen and you were embarrassed or ashamed to report it, there has to be so many, many more victims. There has to be. This guy was on the prowl. He was on the hunt, possibly every single night. January of 2020, Campbell's arrested on charges that he raped the woman he drove from the Harp in December 2019. March 2020, Campbell's indicted in the December 2019 grape. July 2020, Campbell's charged with 6 more alleged grapes and 1 attempted grape dating back to 2017 after investigators found videos and photos on his phone. He's a monster. March, allegedly. Innocent until proven guilty and all. March 2021, Campbell is charged with raping a 9th woman after investigators find images on his phone. They track these women down. December 2024, after many delays, Campbell's case is expected to go to trial in Suffolk Superior Court. Well, that was December 2024. It is now May of 2026, and jury selection is underway. The trial is beginning Monday. Cameras are allowed in, and I hope that one of the media is going to live stream this trial. And we will be there. Please speak out. Tell Law and Crime. Tell Court TV. You want this to be live streamed. Nobody knows about it. They probably don't think there's enough public interest. Maybe the pool camera is going to be Boston 25 and they're just going to run clips, maybe on the nightly news. You should be outraged, whether you live in Massachusetts or not. Both Medford and Boston police declined to answer questions about why they didn't arrest Campbell or search his phone sooner. But a spokesman for the Suffolk County DA's office suggested law enforcement didn't have enough justification to obtain a search warrant for the phone's contents in the earlier cases. Yeah, but they had a DNA match in 2016. They say the victim didn't want to testify. They say. The courts have ruled that police need both reason to think a suspect committed a crime and that the phone contains relevant evidence. Oh, well, remember what they did to Brian Walsh? Remember what they did with Brian Walsh's phone? They had a consent search to search his phone between the district attorney's office and Brian Walsh's attorney. And the consent search was limited to only communications between Brian Walsh and his missing wife between, I don't know, a 2-week period, the week before Christmas and New Year's. And instead they did a complete and total extraction on his phone, found everything, Google searches, location data, and they used it all. So, I mean, really? Really? Quote, police cannot do it simply on a hunch that they might find something, said Jim Borgasani, the agency's spokesman. Boston and Medford police also declined to say why they didn't take other steps to corroborate victim stories when DNA evidence first pointed to Campbell. For example, a longtime manager of the Harp remembers police requested surveillance footage from the bar when they arrested Campbell in 2020. but he doesn't recall anyone contacting him after the alleged assaults in 2017, when Campbell allegedly masqueraded as a bouncer inside the tavern to pick up the two roommates. They never came down and specifically asked us to do anything or look for people, Harp manager Jamie Roberts said. There's a picture of the harp. Nor did police arrest Campbell after victims reported 2 other kinds of physical assaults during the same period. In the first incident, a chauffeur said Campbell attacked him outside South Station in 2016 with a sharp object that left cuts on his right ear and head. According to the driver's request for a harassment prevention order in Lynn District Court, the driver said Campbell fled the scene when police arrived and ignored a verbal order to stop. And in early 2019, Campbell allegedly slammed 2 women to the ground outside a Boston nightclub called The Tunnel when one of the women refused to give Campbell her phone number. Again, police decided not to arrest Campbell, but later pursued an assault and battery charge in Boston's municipal court for attacking one of the women. A judge dismissed the case in February of 2023, saying prosecutors were, quote, not ready for trial. Oh my. Four years and they weren't ready for trial on a simple assault and battery charge. I've never heard this, but you call her Stephanie says, Lynn, the city of sin, you never come out the way you came in. Oh my God. Palace says downtown Boston has so many of these types of cases due to alleged roofies by bartenders. There's a whole Facebook page for awareness. Jeff is like, WTF, lock this man up. Oh, his trial's starting Monday. We don't know if it's going to be live streamed yet. We know that the judge is going to allow cameras in. So please speak out. Please let local media know that you want to see it. I don't have a camera that I can put in the courtroom, but there's going to be one there. A spokesperson for the Suffolk County DA's office said it couldn't try the case that day because the victim did not show up in court. But according to an audio recording of the hearing, they did their due diligence. Judge Stephen Kay said prosecutors failed to bring any other witnesses who could identify the people in a video of the incident. In addition, the judge admonished prosecutors for failing to turn over a detective's interview notes with the victim to the defense lawyers. Boston police declined to explain why they did not arrest Campbell in either case. Police and serial rape cases. Stories like Campbell's are not unique to Boston. Around the country, police have missed opportunities to catch serial rapists again and again. A federal lawsuit last year accused police in Johnson City, Tennessee, of failing to act on complaints that a business owner drugged and raped multiple women. He has since been accused of assaulting more than 50 unconscious women. And a North Carolina television station, WRAL, found police obtained DNA evidence about a serial rapist in Durham long before he was finally arrested. The man in that case has been charged with 4 rapes. In Campbell's case, some experts wonder whether police may have been hesitant to charge him because of his high-profile sister, Attorney General Andrea Campbell, who was then a Boston city councilor. Even if you don't get that call, you know that you better be careful and not mess this one up because it could come down hard on you. Said Samuel Dordulian, a former sex crimes prosecutor and deputy district attorney for Los Angeles County. So if it's one of those cases where it's 50-50 on whether you should file, you'll probably hesitate. Here's a quote from Laura Dunn, an attorney for victims of SA. We need to stop waiting for offenders to have assaulted numerous people before we take action. Boston police declined to comment, however. Medford police and prosecutors in Suffolk and Middlesex County all said Campbell's sister had no impact on the cases. Medford Police Captain Paul Covino said his department wasn't even aware that Alvin Campbell was related to Andrea Campbell until informed by a WBUR reporter, even though dozens of news stories mentioned the connection after his arrest. Molly McGlynn, a spokeswoman for the Attorney General's office, said Andrea Campbell has recused herself from any involvement in the case, has had no contact with law enforcement about the investigation or prosecution, and has not talked with her brother since his arrest. In addition, a Boston Records officer said the city couldn't find any email from Campbell's government account mentioning her brother when she was a city councilor. From her government account. We know they use their private emails in Massachusetts politics. Come on. Andrea Campbell declined requests for an interview, and this is a 2024 article, I remind you. In a statement to WBUR, Campbell said she would never interfere with or influence any investigation, especially one involving such serious allegations. She said the prosecution has her unreserved support. I don't know anything about Andrea Campbell. I really can't opine. I'm sure if you live in Massachusetts, you might have your opinions about Andrea Campbell, but I really don't know anything about her. But she did say that prosecutors in the case against her brother have her unreserved support. And again, these are her comments from 2024. Oh, that's so funny, Olivia. Olivia says, in fact, Michael Marcy emailed Andrea Campbell from his personal email account. Oh, right. What was the sum and substance of that email again? What did Michael Marcy want the feds to do? What was he begging Andrea Campbell to do in that crazy email? Remind me. Did it have to do with Turtle Boy? He wanted more money for the Karen Reed trials as alienated sharpness. He wanted her to prosecute Aiden. Right. That's what it was, B. Crumbs. That's what it was. He really, really wanted her to go after Turtle Boy. Isn't that what it was? And maybe more money too? Libby said it was about the prosecution of Aiden's case in one instance. I think there were multiple emails. Yep. I'm sure one of you will go dig deep into the archives of the Marcy emails, FOIA request, and see if he was emailing her at her private email address or her government email address. This article from 2024 says Alvin Campbell's trial is currently set for December 2024, but has been pushed back repeatedly. That's in part because he has fired at least 4 of his court-appointed attorneys, requiring new lawyers to become familiar with the case. One of Campbell's attorneys, John Hayes, said that Campbell fully denies both the criminal charges and other allegations detailed by police and court records. Those uncharged cases were dropped for a reason, he said in late January. Shortly before Campbell dismissed him. Campbell's various lawyers have also tried to block prosecutors from using photos or video police found on his phone of the alleged assaults. The attorneys argue police didn't have a legal basis to search his device and misused the information to reach out to women who had never reported any assaults to police. The police were no longer investigating reports of SAs. They were seeking out potential victims and telling them that they had been assaulted, Hayes said. There he is again with his mask on. 2023 in court. The public has yet to hear directly from any of the people who were allegedly raped. In court documents, prosecutors referred to the women only by initials to protect their identities, as well they should. WBUR was able to identify one of the victims, the woman who accused Campbell in text messages in late 2019 of raping her when she was drunk. In a brief phone call, the woman said she tries not to think about that night. She met him. WBUR does not name SA victims in stories without their consent, as well they shouldn't. Some experts who study SAs say Campbell's case stands as a warning that the criminal justice system must do more when victims first report SAs to prevent other people from being hurt. We need to stop waiting for offenders to have assaulted numerous people before we take action, said Laura Dunn, an attorney in Washington, D.C., who represents victims of SA. We need to of prosecutors and law enforcement that are willing to actually enforce the laws on the books. Okay, this segment aired April 22nd, 2024. Today is May 14th, 2026. Alvin Campbell Jr.'s trial for the grapes of, I lost count now, is it 8 or 9 women, is starting Monday in Suffolk Superior Court. Alvin, what did I say, Spencer? I didn't mean Spencer. I meant Alvin Campbell Jr. Thank you, WBUR, for the coverage. Right, 2 years ago. Almost exactly 2 years ago, April 22nd, 2024. Try Googling this. You're not going to find much at all. Not much at all. Alvin Campbell Jr. But if you go to Wikipedia, you'll find out about his dad and his grandfather who organized crime figures in Boston going back decades and decades and decades. Let's see what you've got to say. Karen Reed's car goes up for auction at 2. Howie Carr will be live. Thanks. I don't think I'll be here at 2. I have things to do this afternoon. But you guys should go watch it. Go to howiecarr.com and you can listen to it, I guess, live. Allison says that one worst the jury didn't hear. Hakeem Pinkney waited for his settlement, died due to broken ventilator at a cheap care home. Oh, you're going back. You're back on Murdaugh. Thank you, Allison, for your 5. Lucy says, my 10-year-old doggo is named Benson because of my SVU Comfort Marathon when I adopted him. He's now known as Benson P. Wigglebottom Esquire. Law Tube grad. Oh, thanks, Lucy, for tuning in from Canada. Helene Marie says, Uber and Lyft stickers and signs can be bought online. Oh, that's great. That's great. Please, please, if you're going to use them, always check the license plate and the picture of the driver. Please. It's horrifying. Susie says, whenever I hear Melanie talk about there being a draft due to having a bunch of windows open, I let out a little chuckle. Oh, thank you. Thanks, Susie. Thanks for your 5. Bye. Oh, thank you so much, Gigi, for your $50 cash app. Thanks for keeping me company. I love you with all my heart. I love you with all my heart, too. If I don't see you soon, I'm going to die. Advice. Jordan says, check license plate, picture, and do not accept any drinks in the Uber, even if they are closed. Oh, that's good advice, because they do sometimes have little bottles of water in the back. Kelly says, my husband has his own transport business, safer than Uber, LOL. Little Cupcake says, Sister Andrea Campbell's family story was supposed to be some sort of inspiration, as she and her siblings were raised in the foster system after the mom died while dad was in prison. She became the attorney general eventually. How did I find this case? A viewer by the name of Terry sent it to me on Tuesday. And I've been talking about it ever since. I can't shut up about it. Thanks to Terry. If you're here, thank you. James thinks that some rich collector will buy that Lexus. I agree, Kelly. It is the district attorney's fault that the rest of the women were SA'd, in my opinion. Yep. Lisa Roberts said, I saw this case on Facebook. Oh, interesting. Robin says, I wish this reporter, Walter, would have stayed on the case. That was an excellent article. It was longer than I thought, so it took me longer to read than I thought. And I hope my vocal fry wasn't hella annoying to you. But maybe he doesn't work there anymore. I don't know. Another rabbit hole. Big Old Dog says, the Suffolk DA was Rollins and now Hayden, guy who indicted O'Malley. Oh, right. He's indicting the cops, but not the serial grapists. Okay. Scott McGinnis says, the Tower of Corruption in Massachusetts is hundreds of stories high. It's not something to easily fathom. A tower built over decades, systemic and deeply rooted, a foundation in bedrock. Yeah, we got to talking about the Kennedys the other day because the Chappaquiddick movie happened to be on. I happened to watch it, and they were protecting the Kennedys going all the way back, decades and decades and decades and decades. Right? This isn't new. People in Massachusetts know that this has been going on forever. The judge in this case, who's trying this case, is Judge Mary Ames. Anybody know anything about Judge Mary Ames in Suffolk? Let the chat know about it. And we will take it from there. I will be getting documents on this case. We will be looking at them because this is one that I have fallen into the rabbit hole of and I can't get out, and I'm outraged about it. Little Cupcake says, when the powers that be can control who's in power, propping up vulnerable ones who feel like imposters and perhaps like they owe someone something. Common sense investigator, also good advice. When you get into an Uber, make them give you your name before you get in as well. Let's check the license plate. Also pay attention to where you are while driving. Yeah, they're supposed to know your name. I do that. What's my name? Oh, Courtroom Cupcake Charlene says Campbell's mom died in an accident on the way to visit dad in jail. Andre died in custody awaiting trial. Autoimmune disorder that was not treated or treated improperly. I don't know. Oh. PK says, speaking of rabbit holes, I went down one last night looking into the Denver airport and how it was related to the ending of the show Paradise. Well, we covered that the other day. Oh, and that reminds me. Oh, wait, there was one more thing I want to show you. Hold, please. Because this you cannot even make up at all. Hold on. I just got to figure out where I put it. Hang on. Here you go. This is so crazy. This is so crazy. So this was tweeted on May 12th. I think that the jury selection started on the 11th, which was Monday. This was tweeted on Tuesday. Look at this. It's Alvin Campbell, brother of Andrea Campbell, who drove Mayor Wu in the same Uber he assaulted women with. Thanks for protecting men who assault women. And here it is, a tweet by Alvin Campbell from January 29th of 2017, in which he says, I had the great honor of driving Michelle. First thing, she asked me as an Uber driver, how was my day going before giving me direction? Yeah, this guy was driving around your mayor. You know why? Because you can't make it up. You can't make it up. January 29th, 2017. Is your mind blown yet? Mm-hmm. Yeah. Yep. You can't click on it because it's a screenshot of it, but it's there. What? What? All right, my friends, it has been almost 4 hours. Go on over and go to Howie Carr and listen to Howie Carr wherever you listen to Howie Carr. I think howiecarr.com, you can listen to him, or you guys can tell me where you can find him, because apparently Karen Reed's Lexus is going up for auction in approximately 5 minutes. So go check that out. Karen Reed's hearing was canceled today because apparently they've agreed. The town of Canton has agreed, or they've agreed on parameters that they are going to release Sean Good's records, the employment records, and the stuff that Karen's team was looking for. Aiden's hearing is not happening today. It has been put over without date. It was actually supposed to be this morning, but one of his attorneys had a family emergency, is what he said, and so it's not happening today. But, do all the things. Smash the like button. Share the stream out, and I will timestamp this so that the first half is the Murdaugh decision, which I completely agree with. I think he's entitled to a new trial. I've been saying that since 2023. And the second half of the stream was on Alvin Campbell Jr. and the trial that is starting on Monday. And then get out there and tell the media that you want one of them to live stream this trial so that we can watch it together starting Monday, because they should not be trying to hide this from you. Massachusetts friends. Stay cool, stay kind, stay classy, stay safe out there. Above all, don't believe everything you read on the internet. Please hit the like button. Please hit the subscribe button. Make sure your notifications are set to all. Thank the moderators. I could never do this without them. Tip your servers. I'll be here all week. I don't know when I'll see you tomorrow, but I'm sure I will. Peace out, you guys. If I don't see you soon, I'm not going to die. Bye.